extreme urgency. May I mention one matter that I have filed yesterday? I've got the number, but similar matter is appearing as item number 8. It is with regard to 9 and 10 Jawaharlal Nehru Road. Your Lordship was pleased to dispose of the matters in March, and in the teeth of your Lordship's order, corporation is going to demolish the buildings within 3 days. I am in respect of 10 Jawaharlal Nehru. I have filed the writ petition, but it is numbered. If your Lordship is kind enough to take up these matters along with item number 8. But in the meantime, I shall.
Item number 8.
Item number 8 is the similar matter.
Similar matter, but when my petition is getting affirmed, when the matter is called, kindly give us a hearing.
Let us see if any order passed in item number 8 will cover y'all also.
It will cover.
Yes, my matter may be taken up. There, I have got the number.
Let us see. Please let us just wait and see.
Please, your Lordship, my lord, this matter was filed before the Honorable Justice Shompa Sarkar before vacation. But due to change of determination, the matter is not appearing. Yesterday, I came to know that the petitioners were terminated from their service. So my respectful submission, this is the listed matter, my lord. I have filed.
No, so what you want?
I want the matter may be listed under the listed motion, my lord.
It will be listed next month.
My respectful submission, I have told by my client that the petitioners were terminated from their service,
yes,
respective service. That's why I have filed. In the meantime, the happened.
Yes, in the meantime, it happened. Take whatever steps is required to be taken. The matter will be taken up. Why are you
that's why, madam, they were terminated from their service yesterday. After filing this application, they got the petition, my lord. So that's why it is very much extreme urgent, my lord. So my respectful submission.
If subsequent facts have cropped up, they are required to be brought in by way of supplementary affidavit or application or whatever you feel like doing, do it. Then take steps for mentioning. What will the court do now?
Well, at least not to disturb their service. It is very humble.
Without the termination being brought on record, can that be done?
Well, they have issued the letter, my lord. That's why I am.
Please wait. Yes.
Well, this is my respect.
I have expressed my mind. What is to be done?
The file is in court number 19, my lord. That's why my respectful submission. The file may be taken up in this court and the matter may be listed.
The file will come in its usual course. Yes.
Mention that this matter was before the other 48 bench. After change of determination, it's come to lordship. It made returnable on 7th of June. If it so commences to your lordship, I'm suffering an order mentioning upon notice.
Suffering an order of what?
In a writ petition, orders being passed against a private cooperative society.
Yes.
And I have sought for vacating of the order because I have been injuncted.
Where is the application?
Well, everything is listed. It's not listed. It was before the other 48 bench. The bench was hearing the matter. It was returnable on the 7th of June. Upon review.
Please wait. It cannot be done now. Upgradation matters first Monday of the month. First Monday of the month. No, nothing doing. Yes.
May I kindly be permitted for mentioning, my lord, I am praying for restoration application, lordship.
First Monday of the month. Call the list.
My lord, I am under competent circumstances. I am praying, your lordship colleague, hear my submission, my lord.
My lord, I am praying for one enlistment of quantum application, my lord. Because
first Monday of the month. Please give the item number 1. Yes.
My lord, I appear for the petition. I am being led by Mr. Aniruddha Chatterjee. I am praying for a short passover, my lord.
Passover is not possible. Yes. If you want to proceed, otherwise adjourned.
My lord, then kindly adjourn the matter.
Not today.
Yes,
not this week.
Not today.
Not today.
I appear for the petition. Lord. কোনটা দিবি এটা? কোনটা দিবি? Authorized us.
গল্প করছে চার তিনতলা ছিল প্লাস টু
Yes,
Lordship,
408.
Yes, Lordship, kindly come to page 17. Page 17 is the notice under section 401 for stop work. That was dated 27th of July 2022. My lord, on
Please wait.
5th
Please
of
wait,
June.
please wait. Corporation, tell me, if the stop work notice was issued in July 2022 and in June 2023, it took 1 year for you to take steps under section 408. What is the immediate requirement of invoking?
It was sent for the higher authority first of all.
If your higher authority takes 1 year time, then why 408? Why not give an opportunity?
And the petitioner also said right over the matter. When the notice was passed, he never took any objection. And he raised it.
Which notice? Which notice?
For stop work notice.
Why will he raise objection?
But thereafter, we have proceeded with and they have constructed a four-story building. And in the event, without any sanction plan, without any permission, a person can be allowed to be erect a building of a four-story building without any. Any conclusion, sir?
The petitioner is aggrieved by the action on the part of the Kolkata Municipal Corporation in taking steps for demolition of the construction at B by 36C/H/1, Nolin Shorka Street, Ward number 11, under Borough 2 of the Kolkata Municipal Corporation. Stop. It appears that the petitioner has been found to have constructed unauthorizedly a 4-storied building with several columns, beams, slabs, and brickwork. Stop. The said construction was made without obtaining any sanction plan. Stop. A stop work notice was issued under section 401 of the KMC Act on 27th of July 2022 with intimation to the Shampukur police station. Stop. Round the clock police posting was made on 6th August 2022. Stop. The department prepared proposal under section 400 of the KMC Act along with a demolition sketch and infringement statement and placed the same before the higher authority. Stop. The corporation on 6th June 2023 fixed the demolition program for demolition of the unauthorized construction under section 400 within bracket 8 of the KMC Act 1980. Stop. The petitioner submits that there is no immediate requirement of invoking the provision of section 400 within bracket 8 of the Act. Stop. No opportunity of hearing was given to the petitioner prior to taking steps for demolition. Stop. Paragraph. Learned advocate representing the corporation submits that the petitioner sat tight over the matter and did not take any steps after issuance of the stop work notice in July 2022. Stop. Next. It has been submitted that the entire construction has been made without obtaining any sanction plan, and accordingly, the proposal was placed before the higher authority for taking necessary steps. Stop. Next. According to provision of section 400 within bracket 8 of the Act, the mayor and council may take immediate action in relation to any building or work carried on in contravention of the provision of the work for the reasons to be recorded in writing and cause for the work to be demolished forthwith. Stop. Next. In the present case, there is nothing on record to suggest that immediate action is required to be taken in the matter. Stop. The construction in question was admittedly made without obtaining any sanction, and accordingly, a stop work notice was issued way back on 27th July 2022. Stop. Had the mayor and council opined to take steps in the matter, then immediate action ought to have been taken. Stop. Nearly 12 months are over from the date of detection of the unauthorized construction. At such stage, it cannot be said that immediate action is called for. Stop. An opportunity of hearing ought to be given to the petitioner prior to taking steps for demolition. Stop. Next. In view of the matter, comma, the Commissioner of the Kolkata Municipal Corporation or his delegate is directed to take necessary steps to deal with the unauthorized construction in accordance with law at the earliest, but positively within a period of 16 weeks from the date of communication of this order. Stop. Next. The officer in charge, Shampukur Police Station, is directed to keep strict vigil over the property so that construction in any manner whatsoever is not carried out at the subject premises till a decision is taken by the Kolkata Municipal Corporation in this regard. Writ petition stands disposed of. The instruction forwarded by the Executive Engineer, Building Department, Borough 2, signed on 12th June 2023, be written with the records.
The petitioner is the SSC, my lord, of an amalgamated unit. Now, the Kolkata Municipal Corporation, my lord, in respect of the unit in question, has made, my lord, several retrospective assessments of annual value. Would your lordship kindly take up, my lord, the hearing notices at pages 22 and 23 of my lord's brief, my lord? Kindly come to the first hearing notice at page 22. Kindly see on the right-hand side, date of effect, second quarter 2007-2008. Kindly see the date of the notice, 13th January 2021. Bottom left. Lordship is pleased to turn over the page, my lord, to the next page. Date of effect of valuation, right side at the middle of the page, second quarter 2013-2014. Date of the notice, 13 January 2021. Now, my lord, subsequently, my lord, I appeared, my lord, before the hearing officer. The hearing officer has confirmed these valuations. This your lordship would get from the assessment register, which contains the confirmation recorded in the electronic form. That's at page 26 of my lord's brief, my lord. Kindly see, my lord, the columnar thing without, my lord, the lines. That's annual valuation to your lordship's left, immediate left. In the middle of the page, annual valuation in rupees. Kindly ignore the first one. That was the existing one. Now the second one, 513730. Kindly see the next one, 616480. Both are 20th January 2021 is the date of alteration. So that's the date of the order of the hearing officer. And both are with retrospective effect from the effect is also given, my lord, in the next, my lord, in the next column. The first one is from 1st July 2007. It's written in reverse from 2007-071. My lord has found, my lord. And the next one is from 1st July 2013. It's given in reverse from 2013-71. Therefore, my lord, this has now been done, my lord, by the Kolkata Municipal Corporation. My lord, I am relying, my lord, on Shahu Jain.
Shahujan says that they could not have done it. Shahujan is legion, but my lord, for my satisfaction, may I cite it once more, my lord, before your lordship?
When did you get knowledge of this page 26?
Page 26, my lord, we got knowledge in official domain when it was uploaded in the official domain.
When?
Uh,
Date of hearing is January 2021.
Date of hearing is January 2021. After that, they are required to give me a copy of the order of the hearing officer free of cost. That's section 188. That they have not given. But they have uploaded the effect of the alteration on the web portal. I have got it from the web portal.
When?
I have not mentioned, my lord, the exact date, but my lord, your lordship can find, my lord, page 27. At page 27, my lord, kindly sees. That was the LOI.
From 21 to 23, what happened? Nothing.
My lord,
What is 21 to 23? Nothing happened. What is the immediate reason for approaching court?
this is a nullity, therefore directed to be a nullity. They are showing letters of intimation against this, which is the immediate reason. Kindly see page 27. Now, letters of intimation which have been sent, my lord, are on the basis of, your lordship will see the letter of intimation at page 27. Kindly see, my lord, the bill type and the share type. Bill type, after the third column, bill type is all S supplement, and share type is C, which is consolidated. That means supplementary bills of consolidated rate are being now shown as due in the records of the SSE as against the Kolkata Municipal Corporation on the basis of the two valuations that have been made in the year 2021. Now, these are nullities in law because they have violated the law of Shahujan. They could not have gone back more than 3 years from the date of the revising order. This is legion, my lord. I have cited this on a number of occasions. My lord has had occasion to go into this judgment. And now they are showing
September 2022 LOI.
and this letter of intimation, my lord, is dated the 14th of September 2022. Now, I have also made a prayer for cancellation or setting aside. That's 13th April 2023, page 29. It's a detailed prayer. It contains reference to Shahujan. Kindly see at page 35, my lord, there's reference to Shahujan.
You are over.
I am praying for quashment of the orders and the letters of intimation.
In actual fact, what has transpired, not stated in the repetition, then it becomes suppression. And if a fact has been stated, which is contrary to what has actually happened, then it is fraudulent to mislead the court and to derive a benefit not receivable by the assessee. Your lordship has heard two things. He has appeared for a hearing. He was not given the copy of the order. That gives him the jurisdiction to move this repetition after almost 1.5 years. Malad first takes the pink colored pink tag pages.
That is now a tactony.
It is second page. Malad, this is the second page. Your lordship has got the first pink tag. This is the objection docket. Malad, the representative of the assessee went. Malad, would kindly come to the last 3 lines.
I accept it. I accept.
So, Malad, if after going through the records, the authorized representative accepts the valuation, nothing remains, and the copy of the order was handed over to him. Now your lordship would take the second pink tag. Second pink tag. That is, Malad, the assessment book, which is in the physical form. Now,
Here also your lordship would find in the middle. Lordship has seen the middle. Now, there is a 5-storied building. There is a 5-storied building. The earlier assessments were on the vacant land. This 5-storied building was never brought to the notice of the corporation. When at the time of amalgamation, corporation proceeded to determine the valuation, it was found there is a construction, your lordship sees the last king tag, 15,856 square feet. First floor, ground floor, first floor, second floor, third floor, floor. Lordship has seen. On the right hand side of the second king tag document, the second king tag document,
Yes, sir.
left hand side there are revaluation, then the floors are given. It was never, my learned friend has taken it from one list manufacturer, your lordship is aware of, IPG. IPG was the owner, was holding it in lease from WDITC, Industrial Development Corporation. That property was taken up by him. The lease was, the remaining portion of the lease was given to him. Now, this 5-storied building was never disclosed to corporation. This was taken up and it was taken 3 rupees per square feet. The valuation was determined. And he has accepted the decided AV. Maladu, kindly note the name of the person who has given a signature. That is Nawaz Hussain. Even in the first document, that is the objection docket, the name is the same. Malad, the green tags is one. First green tag is the authorization in favor of this Arthur Nawaz Hussain. And the second green tag is his, Malad, that identity card. Am I clear, my lord? Now, my lord, would kindly take the writ petition.
Is it your case that the construction was also made without obtaining any sanction or anything?
I will find during the time of assessment, not a certified copy, but a plan was given, signed by the LBS and the Soumi. Signature of the owner, Soumi HON'BLE Products Director and Joydeep Bilas Thakur. A plan was made. But the fact remains there is a 5-story building. Now, my lord, would kindly take the writ petition. Page 20.
He has affirmed it himself.
Who had appeared in before the hearing officer, who in unequivocal terms has stated that I have accepted, and thereafter after 1.5 years, my lord, the valuation was done on 20th of January.
File a report by way of affidavit.
My lord, I will file, but this writ petition is not at all maintainable.
Yes, take that point in the report. Please come.
For suppression of facts.
Should I return all these papers to you?
My lord, keeps it. My lord,
I'll keep it. Do you have copies?
Yes, I have.
Then I'll keep it here.
I have given my
My lord, I have a submission, my lord, to make before your lordship. Kindly bears me for a second. This fact that he had written, I accept the decided annual valuation, was clearly not informed, my lord, and therefore that is not part of the writ petition. Therefore, the writ petition does not contain something which is a material fact. It is liable to be dismissed, but the Honorable Supreme Court has held that if a material fact has not been brought on record, I'll be very candid because that had to be on record. What the effect of that is a different issue. Whether that creates an estoppel against law and all that are arguments which could have been advanced at the bar, but this was required to be brought on record. If the self-same gentleman has affirmed the writ petition, Lord, kindly permit me to do this. Kindly permit me not to press this writ petition and to challenge this.
My lord,
Sorry,
your lordship,
Or
this is a fraud on court.
this is not a
fraud on court.
this is something which has not been informed, or else not.
Let your client take the responsibility. and suffer the consequences.
No, as far as the consequences are concerned, Lord, I have two submissions to make, my Lord. Since Mr. Mukherjee has,
After he files the report, then.
may I place, my
Not
Lord,
now.
only one judgment
No.
where the SSC had gone and accepted a valuation and your lordships have set aside that valuation,
The
holding that
petitioner,
acceptance does not mean anything.
the
Lord,
petitioner is
Kindly permit me
aggrieved,
to place that judgment once.
the petitioner is aggrieved by the annual valuation assessed by the Kolkata Municipal Corporation in respect of the subject premises from a retrospective date. Stop. Next. Learned advocate representing the Kolkata Municipal Corporation submits upon instructions and produces documents in support of the statement that the annual valuation stood revised after giving an opportunity of hearing to the representative of the petitioner number 1, and the said representative accepted the said valuation. Stop. Next. It has been submitted that the writ petition is liable to be dismissed on the ground of suppression of material facts. Stop. Next.
And suggesting false facts.
And suppression of fact and submitting false facts before the court. Paragraph. Let report by way of an affidavit be filed by the corporation before this court within is 13th, within 27th of June. Exception, if any, may be filed by 6th of July. Returnable on 12th of July 2023.
Obliged, Lordship. Deeply obliged.
Service. Affidavit of service taken on record.
And for the petition, this is the third round. I am challenging the order passed by the special officer, the refusal of the tribunal to grant me interim order, the order which has not been provided to me, and my lord, the subsequent demolition which has been carried on in respect of 5th floor, and the notice which has been given for proposed demolition of the 4th floor.
So many things in one writ petition.
Yes. So
Let
it
us
is coming down, it is coming, it arises out of the order of the special officer. Kindly, my lord, takes the volume 2. My only contention with regard to that is I was not granted appropriate opportunity of hearing. Only on that part of my lord, which is the part which can be gone into by the writ court.
Is anybody representing the private respondents?
No, private respondents have, my lord. Oh, yes, they are there. My lord, kindly comes to page
8,
153.
9 and 10?
No, only 8.
Only 8. 9 and 10, you are not there.
Yes, actually the whole procedure was started. I had moved to your lordship court, lordship had given me.
Very well. 9 and 10, where is the service? Has it been received?
One has been received, other 2 have been marked as absent.
Sathi
She is the complainant.
Sathi is appearing.
Yes.
Shamrat and
Bhanu.
Shamrat item delivered. And Bhanu intimation sent.
Effective persons are there. I'll tell man that is a.
Where is the order of the special officer?
Yes, my lord. Before going, my lord, kindly comes to page 153 and thereafter page 156 is the order of special officer. First interim order. To show that there was no notice, may I just first draw your lordships to 2 notices. This is the first order, my lord, first notice. Kindly see the date fixed 16/1/2023, page 153. I was required to appear on 16/1/2023. Now, our next page, I explained that I could not appear in 16/1/2023, but I have gone there on 19th January and I put this in record by giving a letter. Now, my lord, kindly comes to the interim order of the special officer, page 156. This is the interim order. Now, my lord, kindly comes to the last line of the interim order. Next page, page 157. Next date of hearing will be communicated later. Department is also requested to check the D-sketch and verify at site and place the case without delay. Now, this next date was never intimated. Thereafter, I was served with the order of the special officer, which is 158. This is the service. Page 159 onwards, the order of the special officer starts. Kindly sees, my lord, the top left-hand side, date of hearing, 16/1/2023 and 2nd March 2023. This 2nd March, my lord, I didn't had any notice. Now, my lord, kindly comes to the conclusion of the special officer. Till, my lord, kindly comes to page 160. My lord, till the 3rd paragraph, the interim order which was earlier passed has been set out. Kindly sees. Next date of hearing will be communicated later. Department is also requested to check the state plan. Now, my lord, from the word in response, PR did not produce written submission and as billed during. Further date is scheduled on such and such, but the PR and complaint did not appear. My lord, this notice was never served. Considering the gravity of the situation and massive deviation from the sanction plan, any additional 2 floors are elected. CI shared the structure and cantilever projects has been made on open space. I am inclined to pass the following order. A, to demolish 2 additional floors.
1 minute. 2nd March 2023 order, did you challenge before the
Yes,
tribunal?
this is under challenge.
What happened thereafter?
My lord, I moved this honorable court. Your lordship was pleased to grant a limited stay, and I had moved the, my lord, tribunal. The tribunal had posted the date just 1 day before the vacation, and they were initiating demolition. I had approached before your lordship. Lordship was pleased to pass a detailed order saying that the tribunal ought not to have placed it on the last date and should have considered the interim order. But even on 18th, the matter was heard. I think there has been no interim order granted because they have proceeded with the demolition, but I have applied for the certified copy of the tribunal's order, which as of today has not been given to me. I have the slip to show that. Now, my lord,
What do you want now?
my contention before your lordship is that first is A, B, and C.
No, but then why will the court look into it if it is there before the tribunal?
The tribunal has refused the interim order.
Where is that order?
That has not been given to me. That is the
So how
point.
can the court take it up now?
That is the point. Even in spite of application, my lord, that has not been given to me. And I am going to the order of the special officer to show prima facie that this is totally without opportunity of it. Third is the notice. The notice which has been served.
Wait, still I get the order of the tribunal. Try to understand.
Then they should not have proceeded in demolishing 1 floor.
1 minute. Let
My
me
lord,
try.
they have proceeded in demolition in
So
1
one
floor.
second.
Another point, my lord. 1 point is the main point. That is, my lord, they are very much, my lord, exuberant to proceed to demolish the 4th floor. But they are not exuberant to, my lord, demolish the, my lord, cantilevers and the, my lord, CI shades. Reason is that this is the main reason. Reason is that those structures, I have sold one part of the building to the, my lord, son of the councillor. My lord, that has been constructed by him. They are not at all, my lord, interested, my lord, to demolish those parts, but they are coming.
Which part?
The cantilever and the CI shades.
You have sold it.
Yes, I have sold the ground floor. He has made the cantilever and the CI shades. His associates, they will not demolish that. But the notice as of today, everything, everywhere we have seen that the corporation first goes and touches the ground floor cantilevers for demolition. The corporation in this case is, my lord, after me with regard to demolition of 5th floor. 5th floor they have demolished. 4th floor now they have served a notice upon me. But the contention is that, my lord, I am not occupying the 4th.
Sanction plan.
I have a sanction plan of G+4. G+3.
So
G
the
plus
2
3.
floors are unauthorized.
Yes.
Repeatedly.
But I have, my lord, I have ought to have been given opportunity, my lord. It can be retained.
It can be retained. You make construction without
No, my lord.
construction plan and then it
That
can
is
be
the,
retained.
that should be considered by the tribunal. Provisions are there, but still, my lord, I have a structural stability certificate. My lord, the structure is, my lord, stable. It is no, there is no doubt with regard
What
to
is the
structural
use of
stability.
having these laws? If the structure is stable, there is no requirement of obtaining a sanction.
No,
No, let
that
us
is, that is,
the
that is, my
laws.
lord, that is being determined by the tribunal as to whether the fourth floor can be retained or not. Fifth floor has been demolished, so
Wait,
there
wait,
is
my
nothing with regard to
My
fifth
lord,
floor.
actually, I fail to understand the argument because the demolition process starts from the top. Fifth story building, that is 2 floor extra, unauthorized. We demolished fifth floor. Your lordship's order is very specific. Only 18th tribunal pursuant to your lordship order, hear out the appeal and passed a elaborate order.
Where
The
is
building
that?
is accepted. I have one copy, my lord. Your lordship kindly see how that thing has been dealt with, because that is very unsafe. That technical member observed in page 6 or 5, your lordship, from very beginning. Entire thing has been considered, and the more thing is, my lord, special officer buildings order cannot be challenged before your lordship. Your lordship gave them the liberty to file appeal. Now
That
the
is
order
the
is
reason
marched
the
into
court
that.
is not looking into this order.
That's
This
the
is
lordship.
exactly the reason.
That's
I
the
want to
lordship.
see what the tribunal has done.
Lordship.
And this
Appeal ache, stay decline.
May I have a copy of this order?
Even they have not applied.
It was your matter. It was your responsibility to take.
I have applied, they have not prepared the copy.
Let them show they have applied.
Where from the
They are, my
corporation?
lord, the authority, they can get
No,
anything.
no, before the tribunal, they are nobody.
My lord, they can, I
Nobody.
don't know whether this is a certified copy or not.
Whatever.
If this is a certified copy, my lord, I will, my lord. Yeah, I'm sure it has not been applied.
Assuming it is not a certified copy, that means other copies are available.
They can.
You
Most
also
powerful.
can.
They are most powerful. They can. We cannot.
18th order was passed. Let
This
them
is,
show
this is,
they
my lord,
applied.
this is the application. This is the application.
Even I know how to make applications and keep things stand still.
No, I'm
The court
challenging
is
that.
aware.
I'm challenging that, my lord.
The court is aware as to how far things takes place.
That day itself, my lord, it was applied.
কোন পাতায় আছে দেখ? Last, হ্যাঁ? হ্যাঁ, last one. কি করে দেবো? একটাই একটাই copy আছে। হ্যাঁ?
Second.
ওটা যেটা ছিল যে,
Cantilever, all this construction actually.
Your stay petition has been dismissed.
grateful lordship, because that is very.
So
Keeping, my lord, the appeal pending.
If-
Nothing remains in the appeal.
it's up to you.
Now, my lord, I am challenging this before your lordship.
The
I have challenged this before your lordship in this writ petition. And my lord, the notice kindly sees. Kindly now comes to the impugned notice after this order, page 219. This has been purported to be served upon me, assuming me as the occupier. I am not the occupier of fourth floor. In any case, this notice is bad because it has to be served upon the occupier. I am not the occupier. Page 219A is the typed copy.
Kushal Agarwal,
I am not the occupier.
Who
I
is
am
the
the person representative.
person responsible for making construction.
Alleged. alleged.
Who is the person presently in occupation?
Paragraph ta bolo. Manju Yaduvendru.
You've sold it or what?
It is being occupied by him.
How? How is the?
I have given the possession
How,
have
in
taken-
which manner?
by way of an agreement.
What type of agreement?
That agreement says that you can occupy the premises. But
Today you-
I don't take responsibility as of today.
To,
I am
today
not the occupier.
You may not be the occupier, you are the person responsible, and now tomorrow that Manju or whoever is there will come up and say that no notice has been given to me. This is your case.
No,
It is
my
you who have
contention is
set
it
up-
has to be served upon her.
It is you who have set up that Manju
I have not.
deliberately for
In any
not
case,
implementing,
say-
no, so
say
for
for-
standing in the way of implementing the order of demolition.
my contention is that even if I do not challenge this order as of today, but say I don't have any stake as of today now. Even if it is my bona fide that I'm coming and pointed it to the court that this
Now,
notice has been served.
19, it says it was 15th of May.
Yes.
Thereafter,
Thereafter, this 15th of May, they have demolished. Kindly sees your lordship was pleased to keep this notice in abeyance. May I just place this?
no, this 15th of May is long over.
Yes, your lordship was pleased to keep that notice in abeyance in the second round of litigation. And subsequently on 25th May, accordingly, department demolished this 25th May notice. They have executed. Accordingly, the department demolished the 5th floor, which was unoccupied, but could not demolish the 4th floor and remaining unauthorized persons, which is fully occupied by inhabitants. I am not specific. Thus, you are hereby directed to vacate the above mentioned occupied portion within 7 days so that the KMC can demolish the such and such. This part, my lord, it is not within my it is not within my control to give them a unoccupied portion of the premises.
You don't give, the corporation will take steps to vacate and demolish it.
I am getting.
Now, my lord,
Please come.
here, my lord, kindly considers, my lord, may I just place my case? I have not placed it. In view of the fact that my order, my lord, my prayer for interim order has been refused.
Which police station is this?
My lord, may I just place it, my lord, first?
What else will you place?
In view of the fact that the special officer's order is prima facie, my lord, contrary to the principles of natural justice, and my lord, I have, my lord, already exhausted the appellate remedy before the tribunal. Now everything is open before a lordship. Lordship can go into and, my lord, quash the order of special officer because I have, my lord, in my humble submission, been able to prima facie establish before a lordship that there was no notice served. In none of the dates I have been heard.
Your case was thoroughly considered by the tribunal. Whatever you had to say before the special officer was considered by the tribunal. The tribunal took into
I don't know what is
consideration-
my lord, report of the technical.
Yes, it is.
It has only been quoted. I didn't.
absolutely against
Point
you.
is that moment the technical member is of the view that there should be something which should be considered. I should be given a copy of the same so that I can make my submissions to that effect. The tribunal hastily kindly comes to your lordship's order, last order, kindly comes to your lordship's order, page 213, what your lordship observed. Page 216 onwards. Or rather, my lord, page 215. After hearing the submissions made on behalf of both the parties and upon perusal of the materials on record, it appears that the petitioners were fairly vigilant to get the stay application heard by the tribunal. The learned tribunal, despite notices that the High Court had granted stay for demolition order till 28th April, ought to have taken steps for passing the necessary order in connection with the demolition order. The tribunal ought not to have fixed the matter on 26th April, just 2 days prior to the expiry of the interim protection given to the petitioners. Even accepted that the tribunal fixed the matter on 26th April 2023, the necessary orders ought to have been passed on the stay petition filed by the petitioners, particularly because the stay petition was due to expire on 28th April. The stay petition ought not to have been adjourned without either allowing or rejecting the prayers seeking interim protection in favor of the petitioners till 18th May. Because by that time, the interim protection granted by the Honorable High Court would have lapsed. It goes without saying that the tribunal ought to have appreciated the principle of the maxim actus curiae meum gravet, meaning thereby that no one should be prejudiced nobody should be allowed to suffer the fault of the court. In the present case, though the petitioners took the steps before the appellate forum in due time, but despite the effort, the petitioners were unable to get the stay. It was for the tribunal to pass interim order or at least ad interim order upon consideration of the stay petition filed by the petitioner and ought not to have mechanically adjourned the matter till 18th May. It was also open to the tribunal to reject the prayer of the petitioners so that the petitioners could have approached the higher forum. By keeping the applications of the stay petition pending, the tribunal resisted future course of action by the petitioners. In the meantime, corporation should sought to demolish the structure in question, as the court is prima facie convinced that there was no delay or laches on the part of the petitioners in acting in accordance with the directions passed by the court, and in spite of the best efforts of the petitioners could not get the stay petition heard by the learned tribunal. Accordingly, Assistant Engineer, Building Department, such and such, who issued the impugned notice under section 300,
Please have
544.
gone through it.
Now, my lord, what was the, my lord, breaking my lord, urgency? That was one day before the tribunal. The tribunal ought to have given me an opportunity to give an exception in respect of the, my lord, technical member's opinion. This is merely, I have gone through the order of the tribunal. What is the application of mine? Technical member says this, quote unquote, so therefore it goes. Well, I will not get an opportunity to give my contentions vis-a-vis the, my lord, technical members' opinion. Here, my lord, fact is that, my lord, dismissal of the stay petition is basically, my lord, rendering the appeal infructuous. And as of today, I am also challenging that order of the tribunal, now which has come into light. So therefore, I am, my lord, in my, my lord, humble submission, my lord, I can, my lord, agitate the issue with regard to, my lord, violation of principles of natural justice by the special officer. And admittedly, there was no notice. So therefore, lordship can interfere. And as of today, my lord, what has happened is that, my lord, the tribunal is going to demolish a particular part of the structure. As of today, if I had not even approached this honorable court, then also I don't have any stake in the matter.
If you do not have any stake, don't proceed.
I am only because I have participated in the due process of, my lord, of challenging the orders. I have come before this honorable court.
No,
I have
then you don't have any stake. Why are you proceeding?
No, I am proceeding to substantiate my bona fide that these particular structures could have been retained. The tribunal should have considered this at all. The tribunal has not considered. The tribunal could have said that no, this structure cannot be retained even after
You
retention.
show me the provision of law which permits retention of 2 additional floors
That is on the facts and
constructed
circumstances.
without obtaining any sanction plan. Show me the law.
But there is no law to that effect.
I'll hear it here.
Only point
here
is
and
that
now.
because of the provisions of retention, my lord, there can be retention.
Show me
That
the
the tribunal
provision.
has to decide.
I will decide it here and now. Say,
There is no
where
law to
is
that effect. I am
if
conceding.
there
to
is
that.
no law, how will it be decided?
It has, the tribunal is having the power to regularize. But, my lord, point is what will be regularized by the tribunal has to be considered by the tribunal. That
The
is what I am
court, the
continuing.
tribunal I see has considered. You show me the tribunal cannot go beyond the provision of law.
Yes.
Neither can this court nor can you.
No one.
Show me the provision of law which permits retention of 2 additional floors.
There is no law to that effect. I cannot show that. Even if had that been a law, that would have been ultra vires.
What is to be done now?
Contention is that the tribunal should, my lord, give me an opportunity with regard to the technical members, my lord.
Mr.
And
Lambi,
I will try to
please show me-
substantiate that the entire structure is, my lord, stable and it can hold.
Assuming the structure is stable, I take it that the structure is stable.
I'm, my lord, ready to give the retention fees.
Forget your fees. You can, I know that you can pay 5 times the retention fee.
No, my lord,
It is not that.
that is not the.
Money is not the ultimate thing.
But
There is
tribunal-
a provision of law and you are required to follow it.
But let me, my
Show
lord,
me-
substantiate before the tribunal.
You
that-
show.
That is my contention. The
Please
tribunal
show.
should consider
No,
that.
no, this court will consider. The tribunal has passed order. You are here before this court. This court will consider. Please show what is the law.
Let the, my lord, the opinion, whatever has been expressed by the tribunal, be given to me. I will give a.
Who is going to give it to you? It's your petition.
Tribunal has to give. If the tribunal has not given, the tribunal has proceeded in violation of
The
principles of
order,
natural justice. I
the
should have
order
been given
was
an opportunity
passed by the tribunal.
without giving me the, my lord, quote unquote part which has been, which the tribunal has quoted. I could have given, my lord,
Have
my.
you enough opportunity. You are not
Kindly
available.
remand this matter to the
I
tribunal.
will
What I'm,
not remand it.
what
I
I'm,
will not remand it, I tell you.
Well, what my prayer.
You,
kindly
you have
kindly
made
consider.
submission. You will make the same submission before the tribunal. You want the structure to be retained by process of time, which will
Of
not
course
be
not.
permitted.
Of course not. Let the tribunal
What?
consider as to whether
This
grant
court
me-
will consider.
this court, my lord, would not be having the expertise to consider.
The tribunal
As-
will have it.
Of course, it is a
Yes.
technical member, technical tribunal. I
The
should be given an
technical member has
opportunity.
given the opinion.
That opinion should have been given to me. I should have been granted an opportunity to file an exception to the technical members construction. But that is my only contention. I could have filed an exception to that, saying that the technical member is wrong. And considering my, that is the
Technical
due
member
process.
is wrong, and you are right in making a construction.
I am not saying I should have been given an opportunity. That is my contention. As of today, the only consideration before your lordship is as to the procedure which was adopted by the tribunal is as to whether in consonance with the principles of natural justice.
3,200 square feet has been constructed.
Something has been
illegally.
demolished, half demolished. Now only might be
3,200
my lord, maximum 1,500 is remaining.
The
So therefore, kindly grants the tribunal, kindly
Petitioner-
remands the matter to the
the
tribunal, giving me an
petitioners-
opportunity.
accepts the responsibility of raising unauthorized construction.
No, my lord, this I am not accepting.
You are,
My lord, there was a plan, there has been a construction. My lord, kindly
where
do
is the
not.
plan?
Of course, there's a plan has been.
G+3.
G+3 plan is
Only
there.
the top two floors.
Top two floor, that is.
G+3,
Top-
report
that is not there.
concept
That is
is
not
there.
there. That is not
Corporation is
That is not there. Kindly do not record that I am accepting anything.
You
my
are
lord.
accepting.
Then again, my lord, that will be contrary to the principle that your lordship has recorded in the first order. Well, no one can be prejudiced for approaching the court. That is, my lord,
You can
that I will be
approach the
prejudiced.
Court
That I will be
things
prejudiced if your lordship
with
records that.
things which are legal. You cannot expect any order to be passed for regularization of something which
No,
is
I'm not saying.
patently illegal.
I'm not saying that this court should pass the order. I'm saying that the tribunal should consider.
The-
That is my contention.
The কি বললাম? Construction of 2 additional floors
And the cantilever and the CI shades, that is the most important.
and the cantilever and the CI shed in respect of the premises number 3/1 RK Chatterjee Road, ward number 67, Borough VII, under jurisdiction of the Kolkata Municipal Corporation. Stop next. An order of demolition was passed by the special officer within bracket building. Stop. Primary contention of the petitioners is that no opportunity of hearing was given to them prior to passing the order of demolition by the special officer. Stop. It has been submitted that on 16th January 2023, the matter was taken up for consideration by the special officer, and it was specifically recorded in the order dated 9th February 2023 that the next date of hearing will be communicated later. Stop. The petitioner contends that the subsequent date of hearing was also not communicated to the petitioners, and accordingly, it was not possible for the petitioners to place their case before the special officer building when the matter was taken up for consideration on 2nd March 2023. Stop. Next. The special officer building on 2nd March 2023 passed order for demolition of the unauthorized construction. Stop. Being aggrieved by the same, the petitioners approached the statutory appellate forum, being the building tribunal.
I had approached your lordship remanded, that is. First is
The
170.
Municipal Building Tribunal in BT Appeal number 83 of 2023 took up the application for stay filed by the petitioners and passed order after hearing all the parties. Stop. Next. The learned tribunal took into consideration the opinion of the learned technical member wherein it has been specifically mentioned that the persons responsible constructed 2 additional floors beyond the sanctioned plan, leaving no open spaces either in the front, rear, or the sides. Stop. The car parking space is also not provided as per the sanctioned building plan. Stop. 1 staircase is constructed, though there is provision for construction of 2 staircases. Stop. The staircase which has been constructed is also of less dimension. Stop. CI shed at the side open space of the western side and rear side has been constructed. Stop. Cantilever has been built up on the front and the open sides on the eastern side from the first floor level. The quantum of unauthorized structure is around 3,200 square feet. Stop. The learned tribunal was of the opinion that the quantum of unauthorized construction cannot at all be taken as a minor one and is substantive in nature.
Paragraph 18. Kindly recall
Stop.
that this has not
Next.
been given.
The
Paragraph 18 I have specified.
the tribunal also was of the opinion that the persons responsible made the construction leaving absolutely 0 space on all 4 sides of the building, and the same may turn out to be an absolute mess in day-to-day life of all the inhabitants of the building and the passerbys of the road, including the neighbors of the vicinity. Stop. The forum also recorded that the maintenance of the building during exigency cannot be taken up in view of spaces not being left on any of the sides. Not constructing the second staircase at the whim of the person responsible may create fire hazard in future. Stop. It was also considered that the 2 additional floors would transmit the total load towards the foundation. The unaccounted dead load for the additional 2 floors may imbalance the sanctioned structure, compromising on the quantum of the factor of safety. Factor of safety is within single inverted codes of the building capacity of the foundation, which was taken during sanction of the building plan and is neither desirable nor acceptable. Because of the additional imposing load that is the punching shear, comma, change of bending moment, shear force, may affect the size of the different members, namely compression member, tensile member, reinforcement size, and its distribution for the total building. Stop. The forum was of the opinion that all rules and regulations of the corporation have been violated in making such unauthorized construction, jeopardizing the civil engineering aspect. Stop. The same was to defy the existence and sanctity of the civil engineering aspect and an attempt to show a thumb towards the rules, regulations required to construct a building in accordance with the provisions of law. Stop. Next. It was clearly recorded that any order staying the demolition of such illegal construction would send out a wrong message towards the civil society and may encourage the wrongdoers for doing such type of illegal construction. Stop. Next. Paragraph. The court, the learned tribunal was pleased to dismiss the application seeking stay of the order of demolition passed by the special officer within bracket building. Stop. Next. The learned advocate representing the petitioner submits that copy of the report of the technical member was not served upon the petitioner. Stop. The petitioner was not given any opportunity to take an exception to the report filed by the technical member in support of the stand that the construction that has been made is a stable one and may be regularized. Stop. Next. Despite repeated opportunities granted to the learned advocate representing the petitioner, the learned advocate failed to show or come up with any provision of law which permits regularization of constructions of such massive nature constructed without obtaining any prior sanction plan. Stop. Next. The petitioner presses to remand the matter back to the tribunal for hearing the same afresh. Stop. Next. Upon hearing the submissions made on behalf of all the parties and upon perusal of the materials on record, it appears that the petitioner is hell-bent to hold on to the constructions which have been made without obtaining any sanction from the corporation. Stop. Next. The constructions in question defy as rightly held by the corporation, defy all norms of the all norms of engineering and violates all provisions of the municipal building laws. Stop. Next. Not maintaining any side spaces, raising constructions of 2 additional floors, cantilever, the CI shed are absolutely illegal and there is no chance for regularizing the same. Stop. Next. The tribunal has very rightly formed the opinion that staying demolition of such unauthorized construction will send out a wrong message to the society. Stop. This court is also of the opinion that no leniency ought to be shown to any such construction which have been made without obtaining prior sanction. Stop. Next. The provision of law is very clear to the effect that constructions are required to be made only after obtaining sanction and not prior thereto. Stop. Constructing additional floors and thereafter approaching the corporation for regularization of the same is absolutely contrary to the provisions of law. Stop. Such attempts should be nipped at the bud. Stop. Next. The corporation is liable to take steps for demolition of such unauthorized construction at the earliest. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant writ petition. The writ petition fails and is hereby dismissed. Copy of the order dated 18th May 2023, passed by the Municipal Building Tribunal, Kolkata Municipal Corporation, in BT Appeal number 83 of 2023 be retained with the records.
But the certified copy of that order may be
Affidavit
given.
of service also taken on.
My lord, this certified copy of the tribunal's order may be expeditiously given, my lord. Kindly directs that, my
Go
lord,
and
so that
apply and take it.
it has already been applied on 19.
How could your other side get it?
The other side is a all-powerful corporation. They run the show, my lord. They can get anything.
They run the show at the expenses of the private parties, not at their own cost.
I am not
As
that
a-
private party.
My lord, as a bonus,
My lord, at least the certified copy should be given to me.
6 and 7 কালকে লিভ নিয়েছিলাম বুঝতে পেরেছি 5টা একবার ডাকুন আমি দেখছি
Certified, kindly lights one line, my lord, the certified copy should be given.
certified copy of this order will be given very fast.
No, this
Now this I can assure, but the
That
tribunal's order I
certified
cannot.
I beg to appeal, my lord, on behalf of the petitioner. My lord, the allegation against me is that, my lord, I have raised an unauthorized construction. My lord, this allegation was raised, my lord, by a
Is there
person.
any private respondent?
There is no private response.
There is no private respondent.
My lord, this allegation
How
was,
long will your matter likely to take?
my lord, 10 minutes,
10 minutes.
not more.
Can it be taken up tomorrow?
May I cut short?
No, my lord.
Just
No,
have
no,
got
my
the
lord,
copy
kindly
of the
allow.
application. Notice was given on 14th, Mala. Keep it on day after tomorrow so I can take.
But
the
let
instruction.
no demolition take place
Notice
today and
given on
tomorrow.
14th.
My lord, I will
13th.
come back. There is no difficulty.
Oh.
Demolition is on its way.
Nothing doing. Your notice says that it will be taken up on 14th. Today we are on 13th. How can it be taken up in advance? He is not ready.
In the meantime, I shall take the instruction. Yeah,
Got in the wrong
and I have
foot.
just a copy of the.
Day after tomorrow.
Well, it
Day
says on
after
14th, my lord, tomorrow is 14th, kindly allow.
Take instruction for one day.
My lord, nothing will then will not be left, my lord, for demolition.
Who is
Well,
doing
The
demolition?
demolition
When?
is in swing. My lord, KMC is demolishing, my lord, by construction.
If it is
every day.
demolition, then if you have given notice on 14th, then tomorrow, nothing. Come tomorrow.
My lord, kindly let's.
Tomorrow.
Recorded order, my lord.
What
Recorded
had happened
order.
here is this, my lord.
Why recorded order? It is due to come tomorrow. Your notice
I
that has
know,
been given
I have seen.
says that it will be moved tomorrow.
What,
So it
my
will
lord,
be
what
moved
is
tomorrow.
troubling us, my lord, is that the order of demolition was passed in respect of somebody's property who was not even made a party to the writ petition,
I'll
not
get it
being
tomorrow.
heard.
Come, please give the next matter.
Then, my lord, at least for one day, the demolition should stop.
Is the demolition gone?
Yes,
No inspection, my lord.
it is going on. I am the person who is the owner of the property.
In case it is being demolished, let them wait till tomorrow at least. Let the matter be taken up. I do not know whether it is.
Well,
it is
I
on, your lordship.
have got the copy of the.
Tell your clients, intimate your clients, in the event demolition is taken up, is being taken up,
I shall.
let them wait till tomorrow at least. Call item 6.
And I'm for the petitioner.
State. Yes. Where is the corporation?
Mr. I'm told Mr. Panda is appearing.
There he is.
Now, my lord will.
Stated report, police.
Partial demolition already taken place. 13(6), paid for necessary assistance, will be providing. Very well. Today is the date of demolition.
My lord,
Yes.
it's not-
Demolition is continuing.
my lord, that has had,
You don't know. What is the case?
Milord, kindly come, I am the Milord Bharatiya under the Thika tenant.
Bharatiya under the Thika tenant, yes.
Now, Milord, kindly comes to the earlier round of writ petition, which kindly comes to page 50. Page
Date-
50.
Date of the order?
The date of the order is no, this is Milord the writ petition. I'm coming to the order. Kindly see, one Dhiman Bhattacharya, Somnath, Shantanu, they are the writ petitioners. Now, Milord, against whom the writ petition has been filed, Kolkata Municipal Corporation, and kindly see page 53, 9. Respondent number 9,
Gulab Chand.
admittedly against a dead person, Gulab Chand expired long back, 2023 writ petition. Now, Milord, kindly comes to page 84. What was the order passed in this writ petition? But Gulab Chand was the Milord Thika tenant under whom I am a Bharatiya. Milord, I have got Milord the tenancy. Milord, I'm paying rents to the heirs of Milord Gulab Chand as of today. Now, Milord, kindly comes to the order. Milord, kindly comes to page 85.
Yes.
I'm not placing the entire order, Milord. It appear learned advocates representing the applicant further
You were relegated to the tribunal.
I am no one. I am no one. I made an application for addition of party. Your lordship was pleased to dismiss it. Can
Yes.
one. Now, Milord, what happened? Now, Milord, no notice. Since I am not a party, I am nowhere.
Against whom was this order of demolition passed?
Admittedly, Milord, Gulab, who is a dead person,
Show me that it was passed against Gulab.
oh, that
that
is not the that order. Huh?
but I cannot because
Where
I
is
am
the
no
order
way.
of
No,
demolition?
Because I am no way.
Where is the order of demolition of the special officer?
A special officer order has not been annexed. Only my lord, the notice, which was my lord earlier occasion, it has been my lord demolished pursuant to the order passed by the special officer building 400 subsection.
Where is that order?
That is
That is page, my lord, 84 to 86.
no 84. No. But I do not have that, Milord. I was.
Then how will the court look into the merits of it?
My lord.
I do not
No,
have that.
I have taken instruction that the 400 subsection 1 order was passed against,
Whom?
my lord, against. My lord. That is, my lord, my mobile, I'm against a person.
Because the case that is being made out by the petitioner is that the order was passed against a dead person, the petitioners did not have notice.
Yes, yes,
Is it so or not?
my lord. I'm giving. But the owner and occupier name, my lord, notice served to Sadda, Nadims and others.
Who are they?
My lord, that is, they are not party in this writ petition.
Who are they? Are they heirs or the
My instruction, they are, my lord, the person responsible
for making construction?
for making construction.
And who are the persons in occupation?
My lord, as per the writ petition, the petitioner is the, my lord,
Who was this Dhiman?
my lord, Dhiman is the
Adjacent landowner.
Adjacent.
Yes.
He was the complainant.
My lord, I asked to my client whether you have served a notice to the present writ petitioner. Admittedly, my lord, corporation has not served. That is, my lord, I have candid before your lordships. Even I asked them,
Lordship would-
notice well, issued under whom? They said they are the person responsible. I also, my lord, told them whether they are connected in this property. They, my lord, in
Then
this,
the occupiers ought to be given an opportunity of hearing.
my lord, opportunity was hearing given to them because
Given
Sadda
to
and
whom?
Sadda and Nadim.
Persons responsible for making construction.
Yes.
Why will these
Nasim.
people? Why will these people not be heard?
So because of, my lord, even I also, my lord, put this question: why you have not served 400 subsection 1?
Yes.
Order.
Their answer, my lord, the answer is not the, my officer, the lordship has rejected the can of addition of party. That's why, my lord, we have not served.
Addition of party was rejected. I don't know for what reason it was
My lord.
rejected. But then principles of natural justice is required to be
My lord,
followed.
I bow down your lordship when I put this question, but there is no fruitful answer from my officers.
But till I can see the order of demolition, how can the matter
Only
proceed?
one thing, kindly see page 35.
I can
Kindly see page
my lord,
35.
You
only I can, my lord,
produce instruction.
my lord,
But today is the
no,
date of demolition, no 544 notice, nothing, my lord. Today is the date of
also, I can,
demolition. And state has also, is also saying so.
I'm paying for, sorry, because I am showing this.
No, what is there?
This is, my lord, the notice for, my lord, the notice under section 544 and 546, which was issued on, my lord, 1st February 2023. And on the basis of that, my lord, that notice, we have, my lord, demolished initially. That is, my lord, 20, okay. My lord, page 37(1).
But that is recorded at page 85.
That is 22nd of February 2023. It is over.
Yes.
What about today's demolition? Where is the notice?
No
No notice.
No notice.
How can
sir.
you proceed?
Yes, yes. My lord, that is, my lord, the,
My lord, only one thing, kindly see page 35, my lord. Once,
no notice has been served because of, that is, my lord, the subsequent, my lord, the demolition proceeding.
Alleged unauthorized construction at premises B by 45 by 1 by H by 4. Monoshatala Lane,
PS Watganj.
ward number 77, Boro 9, Police Station Wadganj, Kolkata 700023 is due to be demolished today at the instance of the Kolkata Municipal Corporation. Stop. According to the petitioner, he is a bharatia under the thika tenant of the subject premises. Stop. The recorded thika tenant, one Muhammad
Gulab.
one Golab Chand Agarwal is reported to be dead.
My lord,
Stop.
date of death is 24th October 2020 at page 35. And this writ petition has been filed in 2023. Page 35.
The petitioner has annexed the death certificate of the said Golab Chand Agarwal. At page 35 of the writ petition, stop, the said certificate was issued by the sub-registrar Nimtola Burning Ghat, where the date of death is recorded as 24th October 2020. Stop, next. The specific contention of the petitioner is that no opportunity of hearing was given to the petitioner and no notice of demolition was served upon the petitioner prior to initiating the demolition process. Stop, next. It has been submitted that part demolition took place on 22nd February 2023 pursuant to a notice issued under section 544 and 546 of the KMC Act 1980. Stop. The demolition which is scheduled today was not preceded with any notice of the corporation. Stop, next. Learned advocate representing the Kolkata Municipal Corporation admits that opportunity of hearing was not granted to the petitioner. Stop. It has further been submitted that no notice of demolition was either served upon the petitioner. Stop, next.
Only it has been sent to the concerned police station.
Notice was served upon the police station. Stop. Learned advocate representing the Wadganj police station has obtained instruction from the officer in charge, who has forwarded instruction that pursuant to request made by the Kolkata Municipal Corporation, comma, not the necessary police assistance will be provided to the corporation on 13th June 2023. Stop. Next. It appears from the submissions made on behalf of all the parties that that there has been violation of the principle of natural justice in not affording an opportunity of hearing to the occupiers of the subject premises. Stop. The recorded thika tenant, in the absence of the recorded thika tenant, comma, the bharatiyas who are presently occupying the subject structure ought to have been put on notice prior to effecting the order of demolition. Stop. Next. In view of the above, the men and agents of the Kolkata Municipal Corporation are restrained from acting any further with regard to demolition of the subject structure. Stop. The authority is directed to afford an opportunity of hearing to the occupiers of the subject structure.
Only one writ petitioner, my lord.
There may be others also. You never know. Then they will also come. So
But
there
this
will
is
be
a hard
multiplicity of
milord-
proceedings.
This is a hard milord, just like Thika milord property.
There may be many.
Many, there are others also.
Have you followed?
But
The same
other
address.
person, my lord, if not come, then my lord, the entire proceeding. to be
Suppose they do not come.
My lord.
Will you not give them an opportunity of hearing? Is this the law? You give one notice so that everybody can be heard at the same time. If they are also responsible for making construction, it may be there are separate huts and one has raised construction.
Well-
Others are not required to be given a notice. Then why will you give notice? Only restrict the notices and hearing to the parties where construction has been made unauthorizedly. Otherwise, there is no requirement.
Very well.
কি বললাম? Occupiers of the structures which have been constructed illegally. Acha. Necessary order may be passed at the earliest. The writ petition stands disposed of.
Only one humble submission, but instead of my lord, lordship has not the learned advocate of the Kolkata Municipal Corporation admitted, my lord, on instruction I have submitted. That is, my lord,
Submits upon instruction. Admits a
not
submits upon instruction.
not admitted, my lord, that on
Yes,
instruction.
yes,
I have
I'll on instructions I'm recorded.
Yeah.
Our affidavit of service is taken on record. Call the next matter, please.
Civil Lordship, I beg to appear on behalf of the petitioner. Almost similar case, my lord. Lordship will find from page 27.
I will take it up tomorrow.
No, my lord, today itself, my
Why?
lord.
Today demolition.
Demolition.
Where is the corporation?
My Mr.
Is
Banerjee.
any demolition being taken place today?
I understand today is fixed for.
Demolition. And demolition pursuant to whose order?
No order, my lord.
No order.
No order. I'm showing just a minute, my lord. Page 27, my lord. Kindly see.
Page 27.
Rooftop, my lord, said to my lord, avoid my lord scorching sun and all these things. This was my lord required to be repaired, and that repairing was going on. And my lord, Kolkata Municipal Corporation requested to regularize all things. Page 34 may kindly be looked into, my lord. Annexure P6. On first column number 1, my lord, on 10th May 2023, 401 notice had been issued. And then, my lord, at the bottom, lordship, kindly see, PR has constructed iron frame structure covered by tin shed at the rooftop without any BS plan. Then turn to next page, my lord. This is, my lord, the order of my lord entry. My lord, they would take entry into the premises and to my lord undergo my lord the demolition work. Meanwhile, no hearing, nothing of this sort. Even my lord, here this order was passed. Even if assuming for the sake of his order is passed, 30 days is, my lord, a period for preferring appeal. No copy has been served to us. Nothing of this sort. No 544 notice also. Here also we have received this
1
copy
minute.
from the
Yeah, what
police.
is the instruction?
My lord,
What is your instruction?
yesterday, I have received the whip. Now,
So you not yet.
instruction is received.
The only intimation that has been received that proceedings was under 400 was done, an order was passed.
Where
and
is
on
that
this
order?
text- My lord, I have not received, they are gone today, my lord. My lord, just now I cannot produce. My lord, that is the difficulty.
No, but then the case that is being made out by the petitioner is that there is no proceeding under section 400.
No provision?
There is no proceeding under section 400. No proceeding under section 400.
Under section 400.
My lord, proceedings has been initiated.
Show me the
My lord,
document.
that has been indicated in the letter, my lord. My lord, kindly see.
Not only indication,
order-
not to produce something.
2023, they have taken this particular tree, the order was passed. And 1 month is required to prepare a tree. Even if order was passed by. No cooperation of this sort, no hearing.
Is all the time it is said that no, nothing has been received.
Please come. The petitioner is aggrieved by the
একটা দিচ্ছিল, তোমার যেটা দিতে
action taken on the part of the Kolkata Municipal Corporation in taking steps for demolition,
My lord,
Of
annexer
a construction.
P7, my lord.
which was
Annexer P7.
allegedly constructed without obtaining any sanction. Stop. Next. The specific case of the petitioner is that that no proceeding for demolition was initiated by the Kolkata Municipal Corporation. Stop. Next. Reference has been made to a document which was allegedly pasted. Was this pasted in the wall? Was this pasted in the wall? Where from did you get it?
My lord, the matter may kindly be fixed tomorrow, my lord.
Handed over.
ওগুলো আমি থাকবো না।
This, the petitioner refers to a document which was allegedly handed over to the petitioner by the police, wherein it has been mentioned that steps will be taken for demolition of the alleged unauthorized construction on 13th June 2023, that is today. In pursuance of the order passed by the executive engineer within bracket civil/building, Borough 4 and 5, dated 7th June 2023 under section 400 within bracket 1 of the KMC Act. Stop. Next.
My lord, annexer
According to the provisions of law, comma, an order passed under section 400 is an appealable one. Stop. The statutory period for filing appeal is 30 days. Stop. It appears that order was passed by the executive engineer within bracket civil/building on 7th June 2023, and demolition will be effected today, that is on 13th June 2023. Stop. Next. Learned advocate appearing for the Kolkata Municipal Corporation seeks time to take instruction in the matter. Stop. Let a report by way of affidavit. No, not affidavit. Let a report disclosing all facts in connection with the instant writ petition be placed before this court on 22nd of June 2023. Stop. Next. The men and agents of the Kolkata Municipal Corporation are restrained from proceeding any further with the demolition of the subject structure till 30th June 2023 or until further order, whichever is earlier.
Kindly, my lord,
Service ache?
my lord, kindly direct learned advocate appearing for the Kolkata Municipal Corporation to communicate this order. Today at 12 PM, my lord, that
Please communicate for till 30th. They should not take steps and bring instructions on the next date. Call the next matter, please.
Number 8, number 8, Millard.
Yes, my lord, please.
In this we are all there, Millard. Rashid, kindly, it's his matter, Millard. So Millard, we'll just wait in the office.
Are you demolishing their structure?
What has happened?
Wait.
Portion, my lord, which is a very dangerous condition, that is going to be demolished.
Very dangerous condition.
Yes.
Will you please wait? The dangerous condition, has it cropped up overnight?
So Lordship, I don't have, just now I have taken instruction over telephone. Yes, today I have received the brief.
No, because the notice was served only yesterday or day before yesterday, so they moved on urgent basis.
Yes.
So your clients ought to have forwarded urgent instructions. The matter was heard by the court on earlier occasions.
Yes, Lordship.
There was a direction to to produce plans, to give opportunity of hearing and everything. Has all those steps taken place?
My lord, the owners didn't take any step. Kolkata Corporation has repeated times sent notice to the owners, the Life Insurance Corporation. They didn't take any steps. That's why.
But then the plan was forwarded, if I can remember correctly, plan was produced. It was served upon all the parties.
Yes,
1 minute. If that be so, then what is the immediate reason for demolishing certain portions? Where these portions not before this court on the earlier writ petition? In the earlier,
That was.
it was there.
Yes.
Then
The entire building was.
when is the demolition taking place?
Look, they have asked us to evict and they'll start demolition by tomorrow.
By tomorrow and notice was served.
Already the police posting has come.
In the afternoon on Saturday.
I will take it up tomorrow. You bring instructions because tomorrow demolition will take place,
Lordship.
right? You come with all instructions
Lordship.
and notices and steps taken by the Life Insurance Corporation, the owner and everything.
Lordship.
All right.
I'll submit.
Status is to be maintained, otherwise.
They will not take steps. Don't worry. As it is tomorrow, it will be taken up.
Lordship.
Yes, your matter will also be listed tomorrow. And if your matter is being filed, that will also be listed. Nothing, no order is being passed.
I'm deep blue.
Yeah.
Oh. The appellate side চলে গেছে। But your lordship is switching over to the appellate side.
Very.
Till 12 is the time for
Well-
taking the original side matters. I crossed the time, but there were urgent matters where demolition is taking place today. So it spilled over. Now time is over.
Well, now, my lord, Mr. Dotto is there for the KMC, my lord. We'll have substantial progress.
You are appearing for the KMC.
This is the matter, my lord, where the wiries is.
Which item?
Next matter.
Next one.
Item number 9.
Oh,
Yes.
original side matter.
Yes.
Very
Yes. Wait. Come back later.
Second matter paper. But I beg to appear on behalf of the petitioner. But I mentioned this matter before your lordship on urgent basis. My lord, for the perusal of Mr. Banerjee, my lord, I have craved leave the sanction building plan of not my client, not for making multi-storied building over there. But admittedly, there are certain lots side deviation. But I admit that. That's why, my lord, I have applied before the corporation, whatever they have stated, my lord, all these documents at page 61, my lord would find, my lord, all these documents is being filed for regularization of that minor, my lord, deviation, side deviation. Now, my lord, the crux of the dispute arose, my lord, the last week, my lord, some of the men and agents from the demolition squad, my lord, visited my premises. Page 66, my lord, kindly once looks at. My lord, they stated that in view of this complaint being lodged by one of the member of the Legislative Assembly directly to the Corporation Authority, now, without adhering to any of the provision of 177, my lord, they are now proceeding with the demolition on the basis of this complaint. And the sanction building plan, my lord, is there. But why? What I pray before your lordship, whatever steps the corporation may take, my lord, as per proceeding under section 177, that can be done. But citing, my lord, this letter, they cannot, my lord, proceed with for demolition.
Very well, let me hear.
Right.
Yes.
On seeing this letter, what shall I say? Well, actually, I am spellbound seeing this letter. But anyway, my submission may not be recorded, but we should proceed under section 176.
We are not on that. They straight away will not handed over this letter to my client.
Even after seeing this
Saying that
letter, I have
after this
said,
complaint being lodged, nothing can be done on the behest of the corporation. They will have to demolish.
Who is the complainant?
My lord, the name is there. No, there is no complainant, my lord. This is the complaint.
I have already talked with the commissioner regarding this, and he also said what to do, my lord.
What to do
What
means?
to do? We have told him that we will proceed under section 177, but he said this is an unauthorized construction.
Please come.
So my submission may not be recorded. I have told that we will proceed under section 177.
The petitioner is aggrieved by the action initiated on the part of the Howrah Municipal Corporation in response to a complaint lodged by one Nandita Choudhury, member, West Bengal Legislative Assembly on 22nd May 2023. Stop. Next. The member of the Legislative Assembly lodged complaint before the Commissioner Howrah Municipal Corporation that unauthorized hazardous structure has been constructed at 45 by 14 Choudhury Para Lane, ward number 44, Howrah, and the corporation should take steps to demolish the unauthorized construction. Stop. Next. The learned advocate representing the petitioner submits that on receipt of the aforesaid complaint, the corporation did not take any steps in accordance with the Howrah Municipal Corporation Act, 1980, but proceeded to take steps for demolition of the unauthorized construction without affording any opportunity of hearing to the petitioner. Stop. Next. According to the petitioner, there is a building sanction plan pursuant to which construction has been made. Stop. The petitioner admits that there has been some side deviations at the time of making construction, and application was filed before the Assistant Engineer within bracket Building Department, Howrah Municipal Corporation on 31st May 2023 for regularization of the portions constructed in deviation of the sanctioned building plan. Stop. Next.
Assistant Engineer.
The application of the petitioner seeking regularization of the building plan is pending consideration. Stop.
Well, actually,
It appears that the Howrah Municipal Corporation already initiated BMR case number 87/21-22 for dealing with the unauthorized construction at the subject premises. Stop. You are submitting something?
Assistant engineer is not the appropriate authority to regularization. That
Yeah.
only commissioner, and they should make a letter to the commissioner also.
Stop. Next. According to the municipal laws, the Howrah Municipal Corporation ought to take steps to deal with the unauthorized construction in accordance with the provisions of the law. Stop. The any member of the society can lodge complaint and draw attention of the corporation with regard to any construction which may have been made unauthorizedly. Stop. The corporation, on the basis of the said complaint, is required to initiate proceedings in accordance with the Act and take steps and take further steps to deal with the same. Stop. The member of the Legislative Assembly does not have any special power to direct the commissioner of the corporation to effect demolition of any structure. Stop. Next. In view of the above, the instant writ petition is disposed of by granting liberty to the Commissioner, Howrah Municipal Corporation or his delegate to take steps to deal with any unauthorized construction at the subject premises in accordance with law. Stop. Next.
Including the prayer for.
The prayer of the petitioner seeking regularization of the deviations which were constructed beyond the sanction plan may also be taken up for consideration simultaneously. Stop. An opportunity of hearing shall be provided to the petitioner and all other necessary parties. Stop. If required, spot inspection shall also be conducted to ascertain the nature and extent of unauthorized construction / deviation. Stop. Steps shall be taken to dispose of the matter at the earliest, but positively within a period of 16 weeks from the date of communication of the order. Writ petition stands disposed of.
Till that day, on the basis of this letter, my lord, no worship proceeding. Till that, my lord, decision.
I have already mentioned that the MLA does not have any special power.
Right.
Yes.
Extremely.
Grateful.
My petition, Lordship, but I have served the notice for 14th.
Lordship, 29, I'm for the
14 tomorrow.
Lordship, they have prepared a report, so kindly direct them to give a one copy.
All parties are appearing.
Maybe, but then since date is mentioned in the
There is no mention in the list, Lordship.
No,
not in the list, but the notice.
In my notice.
Notice it has been
Notice, all
mentioned.
the parties appeared. I'm of the municipality.
Lordship,
state
they
and
have
the
given
petitioner.
the
Lordship, the work, the
report I shall gone through the Lordship.
there is an order of stay, Lordship, that is municipality.
Tomorrow কাল
What? Lordship,
আমাকে একটা দিন
the land is not vest.
আমাদের
Land is
সিস্টেমে
vested,
কোথাও নেই
Lordship.
তো 14 তারিখে আসবে।
kindly gone through your Lordship's order dated 27th April 2023. Lordship, kindly gone through.
But then I see an order which mentions that the spot inspection report be filed before this court on 17th of May. Municipality is restrained over the spot inspection till 16th of June or until further orders.
In my land, there is a degree, Lordship also mentioned in the order, and they have restrained by the trial court. And they paper an appeal was dismissed. Lordship, kindly gone through.
Let me see what is the report.
Lordship, kindly give me one copy.
Shall I give them?
Give.
Yeah, I will.
Is the municipality aware?
Lords, yes.
Will you go through and come back?
Yes, Lordship, it will be better. Lordship, it will be better.
This is municipal, BLR has already given us that land is not, that land was vested previously.
Now today's report, see whether it is vested or not. A post-vesting transferee has no right to be served with a notice.
Lordship, this, their version is land is vested.
No, but then the vesting has been set aside by the court. Isn't it?
That
That
is
is
the civil
trial
court
court.
order, Lordship.
Yes.
So what?
Vesting of, to restrain the government from taking any, there is a restraint order of the civil court. Lordship, so far vesting is concerned, that is the civil court has no
Oh,
jurisdiction.
their state has appeared. They have contest. They have
You preferred an appeal.
That is dismissed.
You preferred an appeal, whoever states, it is the vesting of the state. The state preferred an appeal and the appeal got dismissed. A wrong order remains a right order till it is set aside by a superior forum.
Lordship,
Then what can be done?
Lordship, the order which has been passed without any jurisdiction, Lordship.
Go and challenge it before the appropriate forum. This is not the forum.
No, as for the report of the BLR, Lordship, that is the vested. Lordship kindly pass necessary order, Lordship.
Today, Lordship,
Go through it. What is there? Come back. When? Tomorrow?
it will be better. Yes, tomorrow.
No, not tomorrow. Thereafter.
Thereafter tomorrow.
Interim order 16th of June.
And take a note, my lord.
I will take a note. Definitely. Definitely, I'll take a note. Day after tomorrow. Come on Thursday. Report filed by the Blockland and Land Reforms Officer, Shonarpur South 24 Parganas, dated 16th May 2023 is taken on record. Stop. Copy of the same circulated amongst the parties. Pradeep, Thursday? 15th? Acha. List on 15th March, extension of interim order under the same heading.
Get full. Get. Is it?
Mr. Shah, bring those line of judgments where it has been mentioned that a wrong order remains a
Yes,
right
one I
order.
have already given your lordship and another I have.
Please bring.
Yes, I have.
30.
30, my lord, I am for the Kolkata Municipal Corporation.
Yes.
I have to supposed to file a report, my lord. I am praying for, my lord, one week time, my lord.
None appears on behalf of the petitioner at the time of call. Any interim order is there?
I don't know, my lord.
File.
Only, my lord, the report, lordship is directed to file a report.
Learned advocate representing Kolkata Municipal Corporation seeks extension of time for filing the report.
I believe that, my lord, no interim order.
Uh, I was going to dismiss it.
My apologies, my lord. I was addressing in court room number 23.
I can see names of 3 learned counsels appearing for the petitioner. Nobody is here at the time of call. Why is it so?
My lord, I don't have an explanation, my lord, but I was personally addressing. My lord, I just wish to indicate one thing, my lord.
None appears.
My lord, the lordship had allowed the application, my lord, for the purpose of, my lord, incorporating the name. My lord, the amendment, my lord, in the department is to be carried out today. I was only praying, my lord, if lordship fixes any other day for hearing, because lordship wanted to hear.
Very well. Are at foreign line delegacy? Yes. Yes. Right. The amendment, as was directed by the order dated 16th May 2023, is reported to be effected today. Stuff. Next.
Well, to be effected today.
To be effected today. Acha. The matter stands adjourned till 27th of June 2023. Stuff. Learned advocate representing the corporation shall positively produce the report on the adjourned date.
Great, my lord.
Well,
My lord, my apologies for the.
My lord, I am led by Mr. Ranjit Chatterjee, my lord.
Is he not coming to court?
Yes, my lord, he is.
Where?
Lord,
I do not see him.
Code number 6.
No, but then I don't see him.
My lord.
Nothing doing.
He is, my lord, I also, my lord, junior in that matter, my lord.
I cannot help. 31.
Hey.
My lord, I am appearing on behalf of the petitioner, my lord. Yes, today filed a report
yes, my lord.
through today's fixed for file report, my lord,
Dekhi.
by KMC.
31.
One mistake I have, my lord, made.
Again mistake.
One mistake, Lordship has directed to my lord the serve advance copy to be served my lord, to the.
That has not been
It
done.
has not been served, my lord. I am just my lord. Serving.
Let me see what is there in the
Yes,
report. What is the case made out?
My lord, case is the, my lord, construction a new toilet, my lord, in the first floor. For permission, grant permission, my lord, alteration of the plan, my lord.
This is the case, my lord. The petitioners, my lord, make an application for sanction with a toilet. My lord, the first floor. But the corporation has, my lord, rejected his claim on the basis of, my lord, circular 9. My lord, we have, my lord, annexed a circular that they have not.
Which provision? Circular 9?
My lord, I have, my lord, categorically indicated, my lord, the page 3, my lord. To extend the scope of Rule 3.2, read with section 410 of CMC Act, the construction of toilet, prayer room, partition wall, etc., not more than 20% of the total floor area, including staircase of residence building, up to second story, and 50% of the up to third story, without encroaching the right of neighboring building and the right of the co-sharer. These are the condition has to be, my lord.
No, which condition is not being
My lord, the
fulfilled?
entire, my lord, three conditions has to be, my lord, followed. They have, my lord, not, my lord, given us, my lord, the proper plan, my lord, considering the rule 9, circular 9. But that has not been, my lord, submitted. But if they have, my lord, complied with, well, then corporation.
Kindly page 42, my lord. They rejected only another. Yeah, but the condition laid out under the submission plan proposal signed by not been signed by the all owners of the premises. Number 41A.
No, before that, my lord, the proposal violate the condition laid down of the office circular rule, circular 9 of 2013-14, dated so and so, and also submitted a plan proposal has not been signed by the owner. So both.
Yes. What is to be done? You act in accordance with the circular and obtain a sanction and do it.
Yes, ma'am. As per circular, I submit a new building plan, my lord.
When?
Within a week, my lord.
You will submit.
Yes, my lord, I will submit.
We will submit. Please come. The prayer of the petitioners. Prayer of the petitioners. No, not prayer. The plan proposal submitted by the petitioners. For construction of toilet in the first floor level of the premises number 14A, Bacharam Chatterjee Lane, ward number 17, Borough 2 of the Kolkata Municipal Corporation, stood rejected by the Deputy Chief Engineer within brackets civil / building / north on 26th February 2021. Stop. The said plan proposal has not been filed in conformity with the conditions laid down under the office circular number 9 of 2013-2014 dated 30th December 2013. Stop. The said proposal was also not signed by all the owners of the subject premises. Stop. Next. Paragraph. Office circular number 9 of 2013-14 has been filed by the corporation, wherefrom it appears that there are certain conditions which are to be fulfilled and procedure to be followed for sanction of small repairing works, including construction of small toilet. Stuff. Next. in the event the petitioner intends to construct a toilet, comma, then the provisions of the Office Circular number 9 dated 30th December 2013 is liable to be followed. Stop. Next. Learned advocate representing the petitioner submits that his clients will file fresh plan proposal before the Kolkata Municipal Corporation in accordance with the conditions laid down in the Office Circular number 9 of 2013-14. Stop. Paragraph. In view of the above, comma, there is no requirement of interfering with the impugned order of rejection of the petitioner's plan proposal. Stop. It will be open for the petitioners to apply for sanction in accordance with the Office Circular number 9 of 2013-14. With petition disposed.
I'm appealing for the private respondent. May a copy of this affidavit be served for me?
Give a copy.
This matter I am appealing with the petitioner, my lord. I am appealing with the petitioner, my lord. Petitioner challenged the assessment of property tax of the petitioner, and your lordship was on 24th April 2023. Your lordship pleased to direct the municipality to file a report. Municipality filed a report on 18th May, wherein it is mentioned the last paragraph of the report, my lord. Breakup of the calculation of the property of your petitioner is under the custody of the West Bengal Valuation Board. Only measurement sheet of the petitioner property is lying at the municipal office. Last occasion, your lordship was direct to impede a party, the West Bengal Valuation Board. I have served the copy of the.
I'm appearing for valuation board.
And submitted.
At the very first instance, my lord, I'd like to make my submission that this writ petition is not maintainable because there is specific provision of appeal. My lord, kindly come to paragraph 11 of the application.
Which page do I get that?
Paragraph at page 7.
Yes.
My lord, it is admitted position by the petitioner that a draft valuation notice was given to him, and accordingly an hearing was fixed, and which is appearing at paragraph 13. That accordingly, West Bengal Valuation Board in its notice dated 14th of May 2016 under the relevant act conducted a hearing. But the petitioner is silent in this regard, my lord, that he did not mention that in the said hearing, the annual valuation was revised. From our record, it is seen that it is a rental property where he is getting a rental income of rupees 15,300. I have the report, my lord. I'm tendering the report.
Yes, please.
I'll supply the copy of the report.
He is having an income. Hearing, the draft valuation notice was given. Hearing was conducted. In the hearing, annual valuation was revised. All these aspect has not been said.
Was conducted and the petitioner was represented.
He was represented. His signature was there.
All right.
And now the final valuation has been passed. Now there is no provision. Now valuation board cannot do anything. There is provision of appeal. The appellate authority is additional district magistrate. He should prefer appeal. From 2017 to 2021, he kept quiet. He did not prefer any appeal. Now final valuation has been passed. Annual valuation has been revised to him. This is my only humble submission.
Yes.
Leave to file the exception to the.
What is the exception that can be filed?
It is a Xerox
If
copy. This
there-
is the original.
If there is appellate forum, why don't you approach the forum?
Only in 2017, 2016 notice was given, hearing was conducted. He kept quiet for 4 years. Now in 2022, he has come out with it.
The appellate authority wants. Where do I get that?
111 under section 111 of the Municipal Act. I don't have the notification. As per notification, it has been made.
এটা কপি দাও একটা ভাই।
দিয়ে দিচ্ছি। 111 of the municipal act, my lord.
Yes.
There is a specific notification also that additional district magistrate is the
Competent authority.
competent authority.
Please come. The petitioner is aggrieved by the annual valuation that has been fixed in respect of the subject property. Stop. Next. It appears that a draft statement was given to the petitioner, comma, an opportunity of hearing was also afforded to the petitioner, comma, the initial valuation which was fixed stood revised, and thereafter final valuation has been published. Stop. The petitioner is aggrieved by the same. Stop. Next. Learned advocate representing the West Bengal Valuation Board submits that the at this stage, the West Bengal Valuation Board does not have any power to revise the final valuation. Stop. There is a provision for appeal under section 111 of the West Bengal Municipal Act 1993. Stop. Next. Paragraph. Section 111 of the West Bengal Municipal Act 1993 mentions, 111 within bracket 1. Nah. Yes. Subsection 1 mentions that any owner or person liable to pay property tax may, comma, if dissatisfied with the determination of objection, comma, filed by him under section 9 caps A of the West Bengal Valuation Board, comma, 1978, prefer an appeal in writing to the competent authority, CA caps, under the section within 60 days from the date of issuance of the notice under section 11 of the West Bengal Valuation Board Act, comma, 1978. Stop. There is also a provision for condonation of delay in preferring the appeal within the aforesaid time period. Stop. As it appears that there is a statutory provision for preferring appeal against the valuation determined by the West Bengal Valuation Board. Accordingly, it will be open for the petitioners to approach the statutory appellate forum in accordance with law.
There
Writ
is
petition
some,
stands disposed.
as per statute, there is some delay, my lord. And
Yes, you take
please
steps
direct
for
the-
condonation. Why will this court? There is no prayer, nothing of the sort. This court will direct for condoning the delay.
And moreover, tax has not been paid since long. My lord. I'm not on that.
If the appeal be paper automatically.
Disposal. No, the petition is disposed, stands disposal.
Yes, yes, disposed.
That's what.
What is your name?
No, Kaushik Pradhan.
এই প্রদীপ একটা নামের লিস্ট যেটা করার জন্য ওয়েস্ট বেঙ্গল ভ্যালু
My lord, I am for the claims.
The petitioner is not
My
here.
lord-
Were you supposed to produce any report or anything?
My lord, last occasion, my lord was directed to corporation to file the report in the form of affidavit, but affidavit not prepared.
Report is here. Let me see.
আমার চিঠিটাই দিয়েছো? কতটা চিঠি করতে?
Photographs were supposed to be produced. From this photograph, will you,
Not only photographs, Lordship has directed to me to file a report by way of affidavit.
yes,
While I have tried my level best to, my lord, intimate it to the executive engineer to inspect, give a report with photographs. Even, my lord, I have, my lord, issued a notice to the, my lord, the municipal commissioner, my lord, the chief municipal officer.
they are not
Despite, my lord, my notice, my repeated request, no one has, my lord, bothered. My lord, my humble submission now before your lordships, I have, my lord, placed my letter to the, my lord, issued by the commissioner, chief municipal officer. Now your lordships, I am not, my lord, I am the last person to, my lord,
photograph was directed to be produced. From the photograph, will you be able to ascertain as to how many
absolutely,
floors are there?
absolutely not. Not only I am not satisfied with the report. Report specific lordship has directed, and the report lordship has, my lord, kindly see your lordship's order. Lordship's order is very much specific.
Let the engineer come.
Yes, my lord.
Which one to be called
The
for?
Boro
Executive
3,
engineer.
executive ne Boro 3.
Three?
Shantanu Datta.
3 or 4?
Sorry,
4 and 5.
sorry. देखिए, Boro 4, 5, my lord.
4, 5.
Boro 4, Boro 4. 4, 5 is, my lord, the
Same thing.
The Boro 4
Executive
is
engineer.
executive engineer, my lord, the
Come.
Shantanu Datta.
By order dated 10th May 2023, the court directed the executive engineer of the concerned borough to cause spot inspection and file report before this court by way of affidavits supported by photographs of the unauthorized construction. Stop. Paragraph. Learned advocate representing the corporation submits that despite repeated requests made, the engineer failed to affirm the affidavit as directed. Stop. Next. A report which has been forwarded by the sub-assistant engineer, assistant engineer, and executive engineer has been placed. Stop. It appears that the same is absolutely sketchy and does not give any details of the unauthorized construction. Stop. The report mentions that spot inspection was conducted on 10th June 2023 in the presence of the custodian of enemy property and the local police station. Stop. Next. The report does not reveal the nature and extent of unauthorized construction as detected at the time of spot inspection. Stop. Next. It appears that the engineers of the concerned borough are taking the matters extremely lightly. Stop. The conduct of the executive engineer of the borough is far from satisfactory. Stop. The executive engineer of the concerned borough is accordingly directed to remain personally present in court on 28th of June 2023, along with the affidavit giving details of the unauthorized construction with photographs from where it can be ascertained. Now, from where the nature and extent of the unauthorized construction can be ascertained. Stop. A photograph from the front of the unauthorized construction shall be annexed to show as to how many floors have been constructed at the subject premises.
20.
Report filed by the engineers of the corporation signed on 12th June 2023, and one photograph with the same be written with the records.
My lord, lordship has fixed on
And for orders.
Lord.
Date ta dilam na? 28th of June. 28th of June.
28. My lord, my
28.
lord, one line maybe. My lord, I have, my lord, issued a notice to, my lord, request to the, my lord, the municipal commissioner to, my lord, direct to the executive engineer to comply your lordship, sir. Despite that,
Learned advocate for the corporation also submits that a notice was issued by him to the municipal commissioner with request to direct the executive engineer of the concerned borough to affirm the affidavit as per the direction of the court. Stop. Let this said notice be also written with the records.
Well, I appeal for the petition.
Yesterday, matter was taken up, my manager was not here. He directed us on the last petitioner to submit a report, a formal affidavit, when I'm filing this report. Two additional floors have been constructed.
Copy given to him.
It has been to him, in September 2022. The order was passed and I find from the record, my lord, that was also forwarded by speed post to the person responsible in 2022. Now, my lord, they only came through this code when we issued the notice 544 and 546 for demolition. Their only contention that the owners and occupants have been mentioned in the notice. Notice is nothing. Notice your lordship knows 544, 546 only to make an entry. Order to be implemented.
What about the demolition proceeding? Was notice given?
Yes, but notice was given.
So where are the notices?
The copy of the order has been forwarded to him. At page 11.
Not the order, but the proceeding. He ought to have been given an opportunity to place
By
his
order
case.
of 1st February, your lordship was pleased to direct the authority to produce the entire records regarding service also. It includes
In the report, is there anything?
nothing, only stop work notice was directed to serve. Allegation is refusal. Mode of service, nothing. Demolition
Refusal
order,
by
nothing.
whom?
No notice for demolition.
Refusal by whom?
No speed post, other service.
I have not seen that.
That has not, that is our cracks of the matter. Prior to proceeding under that guide of that demolition proceedings, no prior service of notice upon me, paragraph 8 onwards.
Petitioner is the owner of the subject premises.
That is that main case of mine. Nothing survives. Let them proceed in de novo.
Has asked for him take an exception. Let him take exception, my lord. I look into him. Whatever the points he is to take, because I find, my lord, that the copy of the order he has not stated that the copy of the order has been received by him, my lord, in September 2020. Because if the order is received, that is not for an therefore, he says, my lord, about the 544, 543 notice, that he might have the cause, my lord, that the notice has not been served, he has not participated in the proceeding. But I take my instruction with regard to that, let him stating specific exception to this report. And then, if it is not, then your lordship may be pleased to pass an application.
My lord, it is apparent on the face of the record. How can I deny unless that is there? If they say the prior notice
is served properly, then
Your documents does not show that notice was served upon him. Then what is for him to deny that he did not receive? You show that you have served.
I will look into it once again the documents, but I'm submitting to your lordship.
Page 20 of your report.
20 page.
20. I see it is notice to the officer in charge, person responsible, Sheikh Amir Hussain, and
That is not a stop work notice.
stop work notice, right? Then where is the special officer order, page 12, Sheikh Amir Hussain, Rafiza Begum? Where is this Amir Hussain? Is he related to the
Sheikh Amir Hussain and Rafiza Begum and others? They are the person responsible.
Page 13 is the demolition order. Kindly see the nature of the demolition order. Nothing records. This is the order 21st of April that is supposed to be carried out. Kindly see. That is our specific case. They have not denied, not controverted my paragraph 8, 9 onwards.
It's not served, but I look into it. If it is not served, it will not take for the 1 month time to pass a fresh order.
Yes, that can be done.
The additional orders are there. One more per chance, takes there, one more order date, my lord. Then I look into it, whether their service has been effected or not. Then immediately, my lord, matter to be taken up for consideration and fresh order to be passed to
It is a lingering process. I am agreeing. Let them proceed de novo upon service of notice, matter ends there. Otherwise, my right of appeal will go.
It
is not.
Consider whether the 401 or 408
It is all
taken up for consideration.
from the initiation. Unless you controvert my petition, how can I make the reply? Evasive denial amounts to admission.
Please come. Report filed in the form of affidavit on behalf of the Kolkata Municipal Corporation is taken on record. Stop. Copy of the same handed over to the learned advocate representing the petitioner. Stop. Next. Will you take an exception?
If you
Formal
lordship directly
exception.
can, or de novo proceeding, it can be. I am agreeing.
No.
Yes, I asked him to submit and
But they have not denied my allegation in the petition.
Next day,
It's lingering the process.
Wait,
I am inviting for
wait.
de novo proceeding.
The matter stands adjourned till 27th June 2023, when the matter will appear in the list marked for orders. Stop. The petitioner may file an exception prior to the next date of hearing. In the meantime, you take instruction what is to be done.
Interim order already there.
Till
I believe till end of
30th June. I'll do it prior to that.
Gateful till under the heading for orders.
Yes.
Gateful. But I have inquired from my client that no notice is given. And that is why my client is not agreeing to de novo proceeding. It can be done. Gateful till.
I'm for this announcement. 34.
I am for the repetition of my lord. As per direction of my lord, I have sent all the copies to the repetition along with the forwarding letter to the concerning respondents. That is the service.
Wait. Let me see. Who has refused and who is the answering respondent?
Already 4, 18, 19 and 20 have refused.
1 minute. 4,
18.
4 has refused. Executive engineer of the KMC, Boro 3.
Refused. 4, 18, 19 and 20 have refused.
18, 19, 20 are private respondents. They may refuse.
And respondent 9 died.
Respondent number 9 died. Then
And remaining respondent 10, 11, 12, 13 and 14 are in postal remarks as no such person are in this address, but they are within the address.
15, 16, 17 has accepted.
1, 2, 3, 5, 6, 7, 8, 15, 16, 17.
Accepted. And when was this notice served?
13 May 2023. Speed post with AD, I have sent all the
What is your allegation?
allegation regarding unauthorized construction and the Debottar property converted into Thika property.
Where is your objection?
My lord, I am the writ petitioner.
Where is your objection before the authority?
I have sent several objections
Show
regarding
me one. Show me one.
the 53 to 82 as P3.
Page
Page number 53, 82.
53.
Huh.
There is an order of injunction by the
Honorable additional district judge, Sealdah Court, keeping 24 hours police vigil over the property, Your Honor.
if the order of injunction is violated.
Yes.
Are you there for the corporation? Very well. If the order of injunction is violated, then you know what is to be done. The order of injunction was passed sometime in 2012.
Yes, my lord.
Right?
Huh.
Did you approach the learned court below for violation of the order of injunction?
Yes, my lord.
What happened?
But police vigil was there, but subsequently there was no police at all. The order thereafter, the concerning respondent took shelter before the Honorable High Court, and Justice Prosenjit Mandal then pass order directing the property is a trust property and Debottar property. It is not a Thika property. And the concerning respondent failed to produce any Thika challan to support their claim. The only thing, that property belongs to Ishwar Sri Gopalji, Debottar property, Bhait opponent.
No, listen. The corporation will only see whether any unauthorized construction is being made or not. Whether it is Debottar or not, the corporation is not concerned. Only unauthorized construction. Where is that objection that unauthorized construction, the nature of unauthorized construction?
There was a hobnobbing in between the Thika controller, corporation concern, and the OC concern. And that is why unauthorized construction is growing up by leaps and bounds.
What is the nature of unauthorized construction?
There is no permission from the concerning.
What type of construction is being made?
Construction unauthorizedly made. There is no norms regarding permission from the KMC authorities. But there was a hobnobbing. We complained before the concerning commissioner.
What are the details of the unauthorized construction? Details of the unauthorized construction. Is anything mentioned?
They have converted the property, Thika property into converted Debottar property into Thika property, and unauthorized construction G+4 drilling already set up, hobnobbing with the OC concern, the OC Kim Mum.
G+4 structure has been made without any sanction plan.
Yes.
Where is this objection before the corporation? That G+4 structure has been made without any sanction plan. Where is this line?
Lastly, January 20,
2023.
Where is that line? Please come. The petitioner complains of illegal and unauthorized construction over a Devottor property at 153 and 153C, Dr. S.C. Banerjee Road, comma PS Beleghata, Kolkata 700010.
This is the report, my lord.
Please give.
I missed the list.
Kolkata 700010 বললাম তো? Under Borough 3 of the Kolkata Municipal Corporation. Stop. Next. According to the petitioner, the construction of a G+4-story structure has been made without obtaining any sanction from the Kolkata Municipal Corporation. Stop. Next. The petitioner submits that despite complaints lodged before the corporation, comma, steps have not been taken. Paragraph. Learned advocate representing the Kolkata Municipal Corporation produces the instruction dated 14th May 2022, forwarded by the Executive Engineer within bracket Civil/Building Department, Borough 3, wherefrom it appears that on receipt of a complaint of unauthorized construction, comma, the spot was inspected. Stop. On inspection, it revealed that brick walls were constructed illegally in the ground floor. Stop. The person responsible for making construction failed to produce any document in support of such construction. Paragraph. Stop work notice under section 401 of the KMC Act 1980, dated 4th December 2020, was served upon the person responsible for making construction, that is Biplab Shaha, alias Bappa, and others. Stop. Intimation was also served upon the Beliaghata Police Station, and the persons responsible were asked to demolish all unauthorized construction. Vide letter dated 14th May 2022. Stop. Next. The instruction forwarded by the Executive Engineer contains several documents. Stop. From the said documents, it is not very clear as to whether any notice or opportunity of hearing was granted to the necessary parties to deal with the allegation of unauthorized construction. Stop. Demolition sketch appears to have been prepared. Stop. Next. Paragraph. The instruction mentions about construction being made in the ground floor. Stop. The instructions are more than a year. The instructions were obtained more than a year ago. Stop. Next. Learned advocate for the petitioner submits that presently G+4 story structure has been constructed. Stop. Next. The paragraph there. The private respondents remain unrepresented in court. Paragraph. In view of the above, the executive engineer of the concerned borough is directed to cause a fresh spot inspection upon prior notice to all the necessary parties to ascertain the extent and nature of unauthorized construction. Stop. Next. Steps shall be taken in the matter in accordance with law to deal with such unauthorized construction. Stop. The aforesaid proceeding shall be concluded at the earliest, but positively within a period of 16 weeks from the date of communication. 16. From the date of communication of this order. Writ petition stands disposed of. For the petitioner. What is the matter?
Lordship, I'm assailing the last annexure, Your Lordship. Lordship may kindly takes up. At page 112.
Yes.
Lordship, before reading it, Your Lordship, I may be allowed to say, Your Lordship, that this is the premises wherein it belonged to the father of the petitioner, and in the KMC record.
Yes.
And in the KMC record, throughout it was written in the name of the father of the petitioner being Thakurdas Ghosh. Lordship, thereafter, suddenly from the municipal record, from the tax receipts, which is starting from page 88. Lordship may kindly takes page 88. Page 87, page 88. Lordship may kindly takes first page 87. Lordship, this is the premises number, Lordship, the Kolkata Municipal Corporation, and now suddenly the owner becomes the occupier, being Thakurdas Ghosh. Lordship, the next page, page 88, the owner becomes Kolkata Municipal Corporation and occupier is Thakurdas Ghosh. Lordship, prior to this, all the tax receipts which have been issued, which are just before page 87, which is annexure P7, page 85. Lordship may very kindly takes up page 85 and 86. Lordship may kindly says the premises concerned is 40 Rusha Road, that is towards Taliganj. Owner Shri Thakurdas Ghosh. The next page, page 86, also the owner is Thakurdas Ghosh. Lordship, in a nutshell, I may say that this property was purchased by Thakurdas Ghosh. He has constructed a building, a residential building on the same, and thereafter residing there with his son and daughter. There are two tenants. A suit was being later on filed.
Who is your tenant?
Lordship,
Who is your tenant?
Lordship, I've given reference of the tenant since a suit was filed. Lordship, I have not named them, Your Lordship.
Reference, show me.
Lordship.
Is the name of the parties appearing anywhere? Chandan Ghosh versus Rajesh Pandey.
Chandan Ghosh is the son of the, Lordship, I have referred it in paragraph 14, page 7. The suit property and eviction suit is being filed against the
Is
tenant.
CESC
Lordship.
tenant? No.
No. Private party. The suit, the relevant documents of the suit is at page 71. Lordship, these are the private parties. I'm only referring to the document of the suit, Your Lordship. It is between the owner and the landlord and the tenant, only to depict that who is the landlord. Lordship, this continues. There is no substantial change, nothing, no failure of tax, nothing. Nothing could have been provided by KMC, save and except in 2016 and 17, giving reference to their conducted, they have used this word, please come, inventory. Their conducted inventory of immovable properties, from where the name suddenly changes. Your Lordship, on the last date, Your Lordship, on being prima facie satisfied, directed the KMC to come up with a report to show how and when and by what means the name changed from the Thakurdas Ghosh to KMC. Lordship, that is my case.
The petitioner is aggrieved by the order dated 27th of April 2022, passed by the Assessor Collector, Tolly Tax Department, KMC. Wherein the said respondent was of the opinion that the changes in the recorded, changes in the name of the recorded owner of the premises at 40 Rusa Road East, First Lane, was made in conformity with the inventory of immovable properties of the Kolkata Municipal Corporation. Stop. Next. The petitioner relies upon the property tax bills issued by the Kolkata Municipal Corporation. Stop. It appears therefrom that the property in question was recorded in the name of Sri Thakurdas Ghosh. Stop. The said property tax bill suddenly, the property tax bill issued by the corporation for the year 2018-19 changed the name of the recorded owner and incorporated the name of the Kolkata Municipal Corporation and recorded the name of Thakurdas Ghosh as the occupier of the subject property. Stop. Next. The petitioner submits that the property in question was purchased by the said Thakurdas Ghosh, and all along the property was enjoyed by Thakurdas Ghosh and his family members upon payment of taxes to the Kolkata Municipal Corporation. Stop. Next. The paragraph, it appears that till 2015-16, the Kolkata Municipal Corporation raised property tax bills in the name of Thakurdas Ghosh. But all on a sudden, in 2017-18-19, the name of the recorded owner changed from Thakurdas Ghosh to the Kolkata Municipal Corporation, and the erstwhile recorded owner was shown as the occupier of the subject property. Stop. Next. A report has been filed by way of affidavit by the Assessor Collector, Tolly Tax Department, wherein it has been mentioned that as per the direction of the court, it was inquired from the chief valuer and surveyor as to whether change in the records were made upon giving prior notice to the erstwhile recorded owner or their predecessor in interest. Stuff. It was informed by the chief valuer and surveyor that at present no such information is available with the office of the chief valuer and surveyor. Stop. Next paragraph. The court fails to understand as to how a property which is incorporated in the list of incorporated in the list of immovable properties maintained by the Kolkata Municipal Corporation could have been assessed in the name of a private party and tax collected from the private party till the year 2017-18. Stop. It is only after 2018-19 that the property tax bill was raised in the name of the Kolkata Municipal Corporation, showing the erstwhile recorded owner as the occupier. Stop. According to the KMC Act 1980, prior to mutation of a property, an opportunity of hearing ought to have been given to the recorded owner. Stop. The chief valuer and surveyor of the assessment department has failed to produce any document to show that opportunity of hearing was granted to the recorded owner or his successor in interest. Successors in interest. Stop. Next. It appears that the corporation, for reasons best known to them, changed the recordings in the municipal books without affording any opportunity of hearing to the recorded owner or his successors in interest. Stop. The same is impermissible in law. Stop. Next. The petitioner has annexed a document to show that the property in question was purchased by the recorded owner.
There is the deeds are part
And
of the
the
annexure.
deed of sale is annexed to the writ petition. Stop. Next. In view of the above, the order passed by the impugned order passed by the assessor collector, Tolly Tax Department, dated 27th April 2022, is liable to be set aside and is accordingly set aside. Stop. Next. The Kolkata Municipal Corp, you did not implead the chief manager revenue as a party. Assessor collector will not be in a position to take any decision.
Assessor.
The municipal commissioner or his delegate
Municipal commissioner
is directed to grant fresh opportunity of hearing to the petitioners who claim to be the successors in interest of the recorded owner, to produce documents in support of the claim of ownership of the subject property. Stop. Next. The concerned respondent shall, after perusal of all documents, both obtained from the petitioners and the records maintained in the department, shall pass a reasoned order and communicate the same to the petitioner. Stop. Next. It goes without saying that the mutation is only for the purpose of ascertaining the person primarily liable to pay tax, and Kolkata Municipal Corporation does not have the authority to declare ownership of any property. Stop. The ownership of the property flows from the title deeds. Stop. Next. The a decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Writ petition stands disposed of.
My lord, in one
Grateful
place,
to
your
your
lordship
lordship.
is recorded as a chief valuer surveyor of the assessment department. My lord, the chief valuer surveyor department is separate and assessment department is a separate department. Both are separate departments, my lord.
I have directed the commissioner
My lord, in one,
or his delegate.
yes, my lord, in one part of the order, I heard that your lordship directed that recorded that the chief valuer surveyor of the assessment department. That is why I was clarifying.
1 minute. I read it out from your report only.
My lord,
Chief valuer and surveyor to the assessment department.
yes, my lord.
This is what is recorded in page 8 of your report.
To the assessment department, yes.
The chief valuer has given information to the assessment department, not of the assessment.
Then I heard it, Mr.
Maybe I have said it incorrectly. I don't know.
Grateful to your lordship.
Grateful to your lordship.
3টে থেকে গেল।
Thank you.
Wait, please, your lordship, Lord. Lord, to begin with, Lord, this is not an illegal construction matter. Yesterday's matter, my lord,
Wait, let it be called on.
yes. Yes, this is not an unauthorized construction matter. This is a matter with respect to, my lord, dilapidated building. Number one. Number two, my lord, the private respondent is a government agency. The milk supply, my lord, who is there, my lord, in that premises, because he is not vacating, my lord, nothing can be done, my lord, by either by me or the corporation. There are notices by the corporation asking me, my lord, to demolish and repair, but they have kept it, my lord, under lock and key.
To demolish and repair.
My lord, it is in a way. Kindly have a look at the requirement.
Are you representing anybody?
They can
State.
represent the private respondent, the state.
Municipal Corporation, agency.
Yes.
Kindly have a look at page
State.
41 first.
Who is the private respondent?
The government
Milk commissioner.
milk commissioner. The milk commissioner. The state can represent, my lord, the milk commission.
Are you representing respondent numbers 2 and 7 and 8?
Yes.
You are 7 and 8. You are representing?
Kindly looks to, my lord, page 41 first. I'm sorry to
Are the respondent number 6 and 7 different?
6 and 7. Milk commissioner and milk commission. Yes, my lord. One is probably, my lord, the one who heads the entire institution, and the milk commissioner, my lord, is the person, my lord, who is there, my lord, in that premises. Because this is there, my lord, from our representations also, your lordship will find. 70. Starts from 57. There's a milk depot there, my lord, in my premises. 57.
And the Howrah Municipal Corporation is not a party.
Howrah Municipal Corporation is a party, my lord. No, the Howrah Municipal Corporation ke party korish na. The commissioner is the commissioner ke koi, the municipal commissioner ke municipal corporation. So that's a folly, my lord. Lordship kindly adds them, my lord. That's my mistake. The
Now,
person-
where is the notice of the corporation?
Yes, kindly turns to, my lord, page 41 first. This is the notice, first notice. Second notice.
Yes.
And then the second notice, my lord, we wrote to them thereafter. And then comes to 46. And I can do nothing, my lord, because the milk commissioner, my lord, is in possession of that premises. And that's my predicament.
So what will the corporation do?
Now, my problem is, my lord, if they, because
you
if
approach the appropriate forum.
we've approached,
against-
we've done that. We've told them.
Who is
My
the-
lord,
which is the
corporation has the power to, my lord, the milk commissioner. The corporation has the power to, my lord, ask them to vacate so that this can be done. I want the corporation to do that. And that they are in possession, there is no dispute. They've kept it under lock and key, doesn't use it. And that's been under dilapidated, in a dilapidated condition. So it's the milk
They are
commission.
your tenants?
Yes, they accepted rent from me, my lord.
We have already paid for higher authority and submitted all the document action. In 1976, we are
and thereafter his mother or landlord, thereafter the property has been handed over to sons and daughters, and till now, his father is invalidity until 23rd March of 2023, he has already got it. But but property has been already handed over by deed of gift in 2017.
How are you concerned with the
Ownership.
ownership, the deed of gift and everything? You are a tenant in the property. Do you pay rent?
Have already,
Do you pay rent?
yes,
When was the last rent paid? Do you use the property? Why? It's a government will occupy the property by paying rent and not utilizing it.
I have already we are not use the property.
Leave it, vacate it.
I have already ready, but
Yeah.
commissioner is not permitted.
Where who is ready?
Commissioner. The minister.
Then who is standing in the way?
So my lord, order, I shall transfer it.
Who is leading you in this matter? Is anybody leading you in the matter? Who is leading you? Where is Mr. Mukherjee? He is busy in another court. No difficulty. You produce a written instruction from the milk commissioner. Followed? Please come.
My lord's pleasure to record, my lord, that he says that he's willing to vacate.
No way. The matter relates to the premises number 27/1, Khetro Mitro Lane, Post Office Salkia, Howrah Municipal Corporation, under ward number 12, Police Station Golabari. The Howrah Municipal Corporation, stop, next paragraph, huh? The Howrah Municipal Corporation issued a notice under section 180 within bracket 1 of the HMC Act 1980 on 26th of July 2017, directing the petitioners to secure and repair the damaged portions, but not materially altering the entire building. Stop. Next. The notice mentions that failure to comply the above requisition, the commissioner shall take steps under section 180 within bracket 3 and 180 within bracket 4 to execute the works required. Stop. Next. The paragraph, the petitioners submit that the milk commissioner learned advocate representing the milk commissioner admits that the milk commissioner is a tenant in the subject property. Stop. It has further been admitted that the property is not being used for quite some time. Stop. Next. The milk commissioner is directed to file a report by way of affidavit disclosing its stand in respect of the notice issued by the Howrah Municipal Corporation requiring the petitioners to secure and repair the damaged portions of the subject structure. Stop. The report shall clearly mention as to whether the portion held by the milk commissioner as tenant is being utilized by them, comma, the rent paid by the milk commissioner and whether the milk commissioner still requires the property. Stop. The report will also mention as to whether the milk commissioner intends to hand over possession of the same for the purpose of securing and repairing the damaged portions. Stuff. The said report, now the said affidavit shall be prepared and served in advance upon the learned advocate representing the petitioners by 29th of June 2023. Exception, if any, may be filed by 7th July 2023. List on 12th July 2023, marked for orders.
In the meantime, let them not take any coercive measure against me.
What is the coercive measure?
180 subsection 4.
The notice was issued in 2017 and all on a sudden they'll take coercive measures. If they come, you can file connecting applications. We will see to it.
No, the affidavit of service may be
Yes,
kept on.
service taken on record.
Grateful to.
I am for the petitioner, my lord.
Lord, I beg to appear for the private respondent.
Well, I have served, my lord, affidavit service.
Purulia municipality is being represented.
Yes, my lord, Mr. Shogoto Mitro is appearing, my lord. My lord, I had a talk with him. He was scheduled to appear today, my lord.
Very well, maybe he'll come. Yes. What is the matter?
My matter is unauthorized construction made by the private respondent, my lord.
Where is your objection?
My lord, I have made objection, my lord, page 36.
And what is the nature of unauthorized construction?
Construction made by the, my lord, kindly see, first of all, my lord, page, my lord, 26. Kindly see, my lord, page 26. Well, there was the, my lord, on 10 feet wide to common passage. There was construction made G plus 4, 5, 6. My lord, kindly see the construction going on. Kindly see the photographs, my lord. Within 10 feet wide passage, my lord, they have made construction 1 plus G 4, 5, and continuously going on, my lord.
Yes. Who are you?
I am for the neighbors, my lord. I am neighbors.
No longer a neighbor. Demolished by your lordship's order. I tell your lordship, this is a check. This has.
Kindly,
1 minute, 1 minute.
I have annexed my identity, my lord. Kindly see, my lord. I have annexed an identity.
You have annexed the?
My identity, my Aadhaar card and voter card. Where I am reside.
Where will you reside?
On page 19.
Page 36 appears to be a mass petition.
Yes, my lord. I am.
Who is the petitioner? One of the mass three.
Yes, my lord. The petitioner, kindly see the paragraph, page 37, serial number, my lord, 15.
Kamil Hayat, he is the petitioner here. Page 37, serial number 15. Kamil
15.
Hayat, serial number 15.
Kamil Hayat.
Kamil Hayat, he is the petitioner here. Or 23, my lord, 6, 46, Sheikh Maju is the petitioner, my lord.
My lord,
Over.
Yes, my lord.
Lord, this case has a checkered history. My lord, your lordships have passed an order of demolition against them. My lord, demolition carried out. As an act of vengeance, they have filed this writ petition. Now I have the sanction plan G+5. My lord, this is the sanction plan, my lord. I am
Keep it with
getting in construction in accordance to the sanction plan. Your lordship would kindly take your lordship's earlier order, wherein your lordships has dismissed their writ petition.
On the same cause of action.
No, no, no.
We had filed a writ petition against unauthorized construction by them. That has been carried out. Your lordships had passed an order. Against that, they had preferred an appeal. They had even moved to the Honorable Supreme Court, dismissed. Thereafter, the municipality has effected the demolition. So they are no longer prejudiced by any construction, if so whatsoever. Now, second thing, my lord, I am carrying on construction in accordance to the sanction plan. Now, he has not disclosed this entire thing and come up with this writ petition with unclean hands. My lord, that is my second contention. My lord, would kindly your
Very well, I have followed it. Just tell me, suppose he is making construction in accordance with the plan. Where is your objection?
The writ petition, the mass petition is there, my lord.
Let the mass petition remain.
No,
Where he
personally.
construction in accordance with the
No,
plan.
my lord, they are not, my lord, kindly, without rear spaces, within 10 feet wide passage, they are making construction with G+5, 6. This is possible, my lord.
Please come. The petitioners allege illegal and unauthorized construction at the instance of the private respondent number 9. Stop. Allegation is that construction is being made without maintaining the mandatory side open spaces. Stop. Objection filed against such unauthorized construction is pending consideration till date. Learned advocate representing the private respondent submits upon instruction that the present writ petition has been filed out of spite and vengeance. Stop. Reference has been made to the order passed by this court against the petitioners in respect of an unauthorized construction, and the municipality took steps for demolition of the said construction. Stop. After the unauthorized construction of the petitioners were demolished by the municipality, the present writ petition has been filed. Stop. Paragraph. Learned advocate for the private respondent produces a copy of the plan in support of the submission that the construction is being made strictly in accordance with the plan sanctioned by the municipality. It has been submitted that the municipality has sanctioned G+5-storied building to be constructed at the subject premises. Stop. The private respondent is making construction in accordance with the said plan. Stop. Next. The paragraph. From the submissions made on behalf of both the parties and upon perusal of the materials before the court, it appears that the construction in question is being made in accordance with the made pursuant to the plan sanctioned by the Purulia municipality. Stop. Next. The petitioners allege that the mandatory side open spaces are not being maintained. Stop. Next. It will be open for the petitioners to raise fresh objection specifying the alleged illegality, if any, at the time of making construction. Stop. In the event fresh representation is made by the petitioners, the same shall be considered in accordance with law by the Purulia municipality after giving reasonable opportunity of hearing to all the necessary parties. Stop. A reasoned order shall be passed and communicated to the parties immediately thereafter. Stop. If any unauthorized construction is detected, the necessary steps shall be taken by the municipality to deal with the same.
Well, one thing, my lord, we have some, one thing, there's a sanction plan, kindly, they kept his record, my lord.
No.
Well, kindly, sanction plan, my lord, otherwise, my lord, kindly handed over, supply one copy of.
Why? It is his plan. He will give a copy to you.
Kindly reserve your custody, my lord.
No,
Because,
no.
my lord, but they have sanction, my lord, I have not check out his, my lord, sanction plan. Kindly, my lord, keep it here, keep it there, my lord. My lord, kindly. My lord, kindly.
No, no. Yes, next matter. She was unwell.
Was not present at the time of call, but in the morning, he appeared and took time allowed.
She was unwell. How are you, madam, now? You are all right?
All right, but my problem hasn't resolved, my lord.
Hasn't resolved. What is the problem?
Two FIR has been done against two FIR has been done against me to keep my mouth shut. PS told me not to make any complaint and withdraw all the cases which are pending and which which are pending in the High Court.
No, but then what do you want over here?
Lordship,
in this petition, what do you want?
Lordship, I have filed a CAN petition for party addition. The drug peddlers are staying in our premises, my lord. PS took no action.
Did you get a copy of the water supply department's report?
No, lordship.
She was not there on the earlier occasion. Give a copy to her, please.
My lord.
Yes.
I want to share these two things. Please.
The report, police report in the 144-2 proceeding is of the year 2019.
Yes, lordship. Its mass petition has been submitted that time to remove me from locality, from my own house. And this is going on continuous process. They are torturing me and giving fake complaints. Two FIR. This is the four FIR has been done against me. Previously, two FIR in 2017. They attacked me and made fake FIR, which was quashed by Justice Trithankar. And one more in extreme lockdown time with some other people had in.
You take steps before the criminal court, but what do you want here?
My lord, I have filed for the partition wall. I have prayed for the partition wall.
Partition wall?
Because unauthorized, my house is surrounded by unauthorized constructed building without leaving any space, violated all the sanction plan. Instead of G+2, they constructed G+5. Just double of that. Not only that, without leaving any space, they are using our passage. They are disturbing throughout day and night.
So if it is your passage, and and your own property, you can construct a boundary wall
No,
to
my,
protect it.
my lord, it's a KMC, just kindly see, para 19. The person is responsible to make the partition wall. It's according to KMC Act, whoever will construct the building, who will construct the boundary wall first. But they have constructed, they are using our passage, and we don't have any option. We can't stop them. We can't do any type of repair work, construction, nothing, my lord. Even we can't repair our water, drainage, nothing. Because a councillor will not allow us to repair, as it's a common passage. People are, she will not allow.
Common passage means common with whom?
No, because others are also using, that's why it's a common passage. Now,
how can you construct a boundary wall over a common passage?
My lord, it is our passage, but as because
you obtain an order from the civil court declaring that this is your personal property, and then you construct a boundary wall. But as long it is being used as a common passage, how can you construct a boundary wall over there? And if you say that it is my personal property, the other side will come and say that no, this is a common property. Now this court cannot decide.
Lordship, when the construction, unauthorized building construction was going on, I had given many complaints.
That is different. To deal with unauthorized construction is one thing.
Yes, Lordship.
That is different. Your prayer over here, what have you prayed?
For the partition wall, Lordship.
See, this is not the way how prayers are drafted. I can understand that you are moving petitions, but at least what is your prayer? Please to issue an order so that the workers of the councillor and the political goons may not interfere in my matter. What is your matter? The court does not know. Since our security is in danger, we are two females alone. These things cannot be said in the prayers. Prayers is, what do you want from the court?
My lord, I have done, just kindly see the canned petition. I have apologized and made a prayer.
Can? Application for prayer for construction of a partition or boundary wall. But then till you can show that somebody is objecting to your construction, how can the court pass orders in this manner?
My lord, they are obstructing all the time. Even they can't allow me to repair. That's why, Lordship, I came to this court because councillor is
Where
saying.
Is your prayer for repairing? Show me your prayer. I will allow you to repair. What was the requirement of the water supply department to file a report if your prayer is for construction of boundary wall?
My lord, I have made the party to the building department also.
Building department is different and water supply is different. This service pipe. Are you getting water?
No, my lord.
Not getting water. Party has to change the service pipeline because it has become old.
Yes, but we can't do repair work because councillor said she will not allow us to do.
Please, the court will forbid you to change the water pipeline. Are you agreeable to change it?
Yeah, Lordship, but she said she will not allow us to cut the roadside also. She will not allow to cut.
The court is sitting over here. Why are you hearing what your councillor is saying?
Lordship, that's because of that these problems are.
Do you want your water line to be repaired?
Lordship,
Are you agreeable to pay the charges and everything? Because it is your water connection and you have to take the responsibility, the financial responsibility.
Lordship,
Isn't
we
it?
have-
And you are required to construct an underground water reservoir to store the filter water. Have you,
My lord, why we can't take the water normally?
what does
Because-
normal mean?
Because they said it is, we have to
Forget the day. Is there any water connection? Nearby your area, near your locality, where you stay, your premises, your building, whatever.
Yes,
What is
Lordship.
there?
It's a pipeline connection.
It goes straight inside your premises.
Lordship. Yes.
And you can take the water from there.
Because there are so many unauthorized construction had been done already. They are taking water by motors.
By?
So by taking from machines. They are taking by.
If the pipeline is not functioning, how can the water be collected by machines?
No, they said the water department told me if you will, if the pipeline will be replaced, then also you will not get the water properly, because the flow of water is very low. The unauthorized buildings are taking water by their by suction machines. They are taking by pump. So just because of that, we will not get water.
Did you ever file any petition objecting to such unauthorized constructions?
Lordship.
Where are those petitions disposed of?
Yes, it is disposed of. One Justice Aniruddha Bose has.
However, it has been disposed of.
Yes, Lordship, and order, the contempt also disposed of, and the order has been passed to the to take demolition. No, the KMC and the state said we will do the demolition process. We will start the demolition process soon, and the demolition will be done in 2018. But till today, nothing has been done. Everything is.
What steps have you taken for implementing the order of demolition?
Lordship, I have given all the orders to different departments, to the building department and everywhere.
Can you show me the order of demolition?
No, Lordship, it's not. I'm not carrying that one also right now.
But here the executive engineer of the water supply department has forwarded the instruction which mentions that your connection is an old one. And to get the normal filter water supply, you have to change the service pipe.
But he also told me, if you will replace the connection, you will not get the water, because the water is coming very low.
Till you replace it, how will you get to know as to what will happen?
My lord, it's not me. The water department told me. The engineers came.
So you go by whatever they have told you?
Yes, Lordship.
Then you go. What is the use of coming to court? There is no use. You act in accordance with what the councillor says.
No.
You act in accordance with the executive engineers.
Lordship, I'm extremely sorry, Lordship, but I am saying when the department came for inspection that day, it's not written there, but that time they told me, if you will replace the connection, then also you will not get the water, but it's not mentioned over here.
Now, how will the court get to know? The court does not get to know.
Yes, Lord.
So you have to take steps for repairing your water connection. You can take steps. And for that, you are to apply through a licensed plumber of the corporation.
License?
A plumber.
Oh, okay, Lordship.
Licensed plumber, Kolkata Municipal Corporation.
Lordship.
Has a list of plumbers.
Lordship,
you can get the list in the official website. You can engage anybody according to your choice. Pay the necessary charges.
But Lordship, the people of councillor will not allow me, they are, when the the people will come for the inspection. They also that time obstructing me. They were not allowing me to speak with them.
Mr. Ghosh, please find a solution to this.
Let her get a sanction, and if it is, if she fails to get the
Thing is, she,
executed, then applicable orders to be passed by this court.
My lord, when
I can understand. But then, she may not be able to get hold of a licensed building plumber. Why don't the executive engineer engage somebody? In the other matter, the court solicited your help.
Someone, my lord, because ultimately he has to engage certain papers to be submitted to the department, my lord. Engagement, my lord, the department can name, my lord, someone to work as his as a licensed plumber, and then what the papers and documents he has to supply to him.
No, she will certainly supply the documents that are required.
Then, my lord, the permission, whatever the permission is granted as my lord, the reported, and then, my lord, if she feels any difficulty to execute the order, then applicable order to be passed.
My lord, I want to say something. When I raise the voice that councillor is stopping me from doing the repair work, PS has made 2 fake FIR against me. Kindly understand what type of situation I'm facing.
What can the court do? You have to understand that everybody has to follow the process of law. So if you are required to engage a licensed plumber for obtaining necessary permission for execution of the repairing work, you have to do it. The court can always come to your aid. What more will the court do? The court is not going to go and fight the councillor over there, isn't it? Then will you be agreeable to engage anybody who the executive engineer suggests? Possibly not. You will engage somebody of your own. So you do that. You engage and you make application. I will keep your writ petition pending. In case you find any difficulty, you approach court. You can file applications or you can mention the matter so that necessary orders can be passed. Have you followed? You take a report from, I'll direct the learned counsel to give you a report and you act in a, you have, you go through it. Whatever is required to be done, do it. Mr. Ghosh is there. He'll always help you out. Have you followed?
Lordship.
Please come. The report dated 25th of April 2023. And 24th April 2023. Signed by the Executive Engineer, Borough 6, Kolkata Municipal Corporation. Has been handed over to the petitioner appearing in person. Stop. Next. It appears from the report that the entire internal drainage system of the existing building at premises number 4/1/H/4, Nawab Abdul Latif Street is required to be rectified to avoid drainage hazards. And the filter and the service pipe of the filter water connection of the said premises is very old. Stop. To get the normal filter water supply, the petitioner is required to change the service pipeline by engaging the licensed plumber of the KMC at her own cost after taking prior approval from the KMC. Stop. The petitioner is also required to construct an underground water reservoir to restore the filter water for her own use. Not restore, but store the filter water for her own use. Stop. Next. The petitioner will be at liberty to act in accordance with the Direction passed by the Water Supply Department. Stop. The liberty to mention.
Lordship, what about the drainage? Drainage has been
Drainage
done
has-
by councillor. She has done it. She has made it
Your
like
personal
that.
drainage, how will the councillor do?
It is in our passage, but councillor has done last time when she was elected, before the election, she has done it.
What she has done?
She has covered the drainage. Just because of that, she is not allowing us to do any kind of repair work. She has done the construction, floor. She has done the floor in our
Floor and
passage.
drainage are separate things.
Yes, my lord, drainage is not visible.
Yes,
Is not visible. It should be visible. It is not visible because she has done the construction like that. And just because of that, we are facing this kind of problem.
but then
Drainage should be visible. That time when the drainage department came, they were saying, where is drainage? I have shown this is the place where you are standing. This is. Then he said, এটা তো চোখ করা আছে, এটা তো এরকম করা যায় না, কি করে এটা আছে? এটা তো মানুষ মরে যাবে।
no, but then if the
She
drainage
has done, lordship.
then she has done, you file case against her before the appropriate forum. Here, the corporation is the party, the councillor has no role. Yes, call the next matter, please.
Grateful, lordship.
My lord, I am appearing on behalf of the petitioner.
Your lordship, in
Yes.
this matter, I am led by Mr. Raghunath Chakraborty Miller. And I am appearing for the respondent number 10. Your lordship, I am praying for a very short passover. He is engaged in courtroom number.
You are here, we can continue.
Lord, my
If
senior
required, I'll pass it over. Let me see,
Milord,
what is the allegation?
My lord, order of demolition has already been passed against them 8 months ago.
How many months? 8?
8 months ago.
Yes.
Till the date, that has not been executed by the corporation.
Milord
Which
is
corporation? Which corporation?
Chandannagar Municipal Corporation.
All right. Where is the order of demolition?
My lord, page number 33.
33.
Milord, a statutory appeal is pending before the competent authority, Milord, of the corporation.
What is the
Milord.
number?
That's a misconceived appeal, my lord.
Misconceived appeal?
Yes, ma'am.
What is the number? What is the number?
Number of Milord.
Appeal?
Milord, number. we
Appeal,
are not-
appeal
we
up
have not
against
been-
which? This was passed by the, in terms of the, your lordship's judgment, my lord, this order was, impugned order was passed, my lord.
Milord, in
Which book
previous.
is this?
My lord, the Corporation Act, my lord. Right, my lord. Municipal Corporation Act.
Municipal Corporation Act. Yes.
The section 266, subsection 3.
Yes, 266.
Subsection 3.
Yes.
Against the order of the commissioner, if anyone is aggrieved, my lord, earlier, prior to the amendment, the appeal was preferable before the mayor.
Now it has been amended.
Yes, after 2017, it has been amended. Despite having such information, people are intentionally filing this appeal before
Milord,
the
that
mayor.
has to be answered.
Yes,
Milord, that
But
has to be
Particularly
seek-
to avoid the
My lord,
proceedings.
corporation. Milord,
tendency of that appeal, my lord, cannot
Authority has to
stand in the way of a
answer.
demolition. my lord.
Now today.
Why are you not demolishing?
My lord, within 6 weeks, it will be done, my lord. But there is some difficulty.
What is the difficulty?
My statutory right of appeal goes away, Milord. I have already.
Where is the appeal?
Milord, now my learned senior friend is saying that there is no, it is a misconceived appeal, Milord. Today, this plea is taken.
No, it is not for him to take a plea. It is for you to file the appeal before the competent authority. You go and file the appeal before the.
Milord, there is no competent authority. There is no building tribunal. Put a challenge.
তাহলে
Building
কোথায় appeal টা
tri-
করেছে?
There is no tribunal that could have been challenged before your lordship, my lord. They are intentionally avoiding this bench, my lord.
There is no tribunal.
Avoiding this
Yes, my
bench.
lord.
Milord, if there is no tribunal, Milord, before whom I should ventilate my grievance, Milord, I am putting. this
Is
question
the
to my
court
court.
the advisory authority where you will go?
Milord, if the statute gives me a right to go for an appeal against an order of demolition, Milord, and
Go. Who is stopping you?
Milord, we have already filed that appeal, but
No, you have not filed. Please try to
Milord,
understand.
corporation has
Come.
accepted this one, Milord.
Please come.
Milord, in this respect, Milord, I am only seeking for at least a short
The-
passover, Milord.
Petitioner placed for implementation of the order of demolition dated 22nd of September 2022 passed by the Commissioner, Chandannagar Municipal Corporation. Stop. Next. Learned advocate representing the private respondent. Which one are you representing? Both?
10.
Only 10. Respondent number 10. Where is the Wakalatnama?
Well, I have already filed it.
In respect of the respondent number 10, submits upon instruction that an appeal against the said order was preferred before the mayor of the corporation. Stop. Next. Learned advocate representing the Chandannagar Municipal Corporation submits upon instruction that mayor is not the appellate authority, and accordingly, any appeal preferred before the mayor is non-est in the eye of law. Stop. Next.
Lord, will kindly record that there is no building tribunal as on this date.
Forget the building tribunal.
Lord, that is the only submission.
No, sorry, you have failed to understand the submission. Paragraph. It appears from the submissions made on behalf of all the parties that as on date, there is no order passed by any competent forum setting aside / staying / modifying the order of demolition passed by the Chandannagar Municipal Corporation way back on 22nd of September 2022. Stop. Next. The Chandannagar Municipal Corporation is duty bound to implement the order. Implement the said order. Stop. Next. In view of the above,
there are certain facts which has to be decided.
The instant writ petition is disposed of by directing the Chandannagar Municipal Corporation to take steps for implementing the direction passed in the order dated 22nd of September 2022 in accordance with law.
Lord, there are certain aspects which has to be considered, my lord, before the demolition order was passed by the commissioner, my lord.
At the earliest, and positively within a period of 16 weeks from the date of communication of this order. The writ petition stands disposed of.
Grateful to your lordship.
Some findings there were, my lord.
Affidavit of service be kept with the
Service
record.
taken on record.
But I appear for the private respondent.
Hey, Pradeep. Pradeep.
But I appear for the private respondent.
Petitioner? Nobody is there for the petitioner?
It is not a case of unauthorized construction, but kindly see paragraphs 8 and 9 of the writ petition once.
Who mentioned the matter?
My lord, it is an old dilapidated building over which, my lord, there is a civil suit pending.
Who are you?
But I am a private respondent co-owner. And my lord, the petitioner is also a co-owner. There are civil suits pending, partition suits, my lord, in which there are orders of injunction passed by the competent civil court. Now, my lord, his case is building has become old and dilapidated. So remove all your belongings from that building and move out. The municipality should demolish the building. But kindly comes to paragraphs 8 and 9 at page
But then
6.
in the absence of the petitioner, why will the court look into all these things? Monthly list of May. The matter was appearing in the combined monthly list of May 2023. The same was mentioned for upgradation, citing urgency. Stop. At the time of call, none appears on behalf of the petitioner. Stop. The private respondent and the Boranagar municipality are represented. Stop. Let the matter appear in the combined monthly list of July 2023.
For the petitioner, my lord.
Beg to appear on behalf of the state lords.
In this case, my lord, the Bajbira municipality issued a stop construction notice against the private respondent number 6 and 7, who started construction encroaching a public passage. Now the passage ends in a pond. They started construction over the end point of this passage. Now in the said stop construction notice, they mentioned that the premises number is 29 Mohakalitala Road. In spite of notice, they started construction, filed a writ petition. This writ petition disposed of directing the Bajbira municipality to make an inspection and to take action in accordance with law. Then, my lord, Bajbira municipality says the premises number 29, which number they have given, no such construction is going on there. Actually, the plot where construction is going on and premises number 29 given is different in plot. We made another representation saying you make inspection properly, the premises number, the plot number where construction going on, everything went, but they did not take any step. That is the grievance, my lord. Lordship, can you see for a moment on page 75, the stop work notice issued by the Bajbira municipality. Totally misguided the plaintiff, petitioner, and this honorable court.
I see an order passed by Justice Sarkar.
Lordship, now kindly see the order first line, page 76.
Yes.
Petitioners have alleged that the respondent number 6 and 7 have raised certain illegal construction on premises number 29 Mohakalitala Main Road, ward number 7 under Bajbira municipality. This premises number 29, my lord, no such illegal construction is going on. But this number is given by the Bajbira municipality in stop work notice. I totally misguided.
I did not follow. 29, no construction is going on.
No construction going on.
But then
they given
you have submitted that it is 29.
Well, kindly see for a moment, page 75. Page 75, the stop work notice.
Page 75, stop work
75,
notice.
yes. You have, it is given to the private respondent number 6. You have already required by the members of Board of Administrators of Bajbira municipality under section 220 of the West Bengal Municipal Act 1993 to discontinue forthwith construction of building at premises number 29 Mohakalitala Main Road, ward number 7, as the same has been commenced without sanction and sanction of building plan and in breach of the provision of act, pending the decision of the municipality. Number have been given by them. When they have, yes, this is the number given by the Bajbira municipality.
What is your case, will you say?
Challenging this, they have our point is that, my lord, they have started construction over a common passage, and common passage has a premises number. But when lodged a complaint, Bajbira municipality given this notice saying that it is premises number 29.
You tell me over which premises the unauthorized construction is going on.
Kindly see, my lord, the last annexure, page 79.
Yes.
Yes. Starting of unauthorized construction over a plot of land under Moija Bajbira, GL number 053, RS plot number 1048, corresponding to LR plot number 1479, District Hooghly, ward number 7.
Isn't there any address as such?
No, my
Their
lord,
number, plot number, nothing.
Ward number 7, but no premises number is there.
There is no premises
No,
number.
my lord. It is a
And it
common.
is over here that the construction is going on.
Lordship.
At the instance of the private respondent.
Lordship.
Who is for the private respondent?
I am repeating that.
Yes.
At the on selection observation, this petition was disposed of by certain directions, page 76.
Yes.
That order was complied with. All the directions they have kept suppressed.
Complied with by whom?
The municipality. Inspection was held.
Over which plot of land? Which plot of land?
Plot of land is not
Premises number 29.
29, premises number 29.
Are you the occupier of premises number 29?
Number 29.
Is there any separate?
On that 29, the earlier petition was filed, not that.
Is there a separate plot number 1048 where you are raising construction?
That
1048 is.
48, there was a civil suit is pending, but they have filed. They have filed page P5. Kindly come to page P5.
1048. Are you raising any construction?
There is according to them, it is a common passage and encroachment of common passage. I will say no. There is on that ground, there is civil suit is pending at their instance. Page.
Premises number 29. Premises number 29 and plot number 1048. Are they same?
There are two plots, 1048, 46, so far as I have a second, 1046 and 1048. two plots have same premises number, 1046, 1048.
Two plots have got same premises number,
Yes.
different owners.
Owners are same.
Owners are also same.
Municipality may have to proper inspection.
Two plots having same premises number corresponding to LR plot number 147.
The civil suit is pending. It's almost at the.
Is a civil suit between you and the petitioner regarding?
Regarding on this.
Regarding declaration, I'm telling my lord.
According to them, it is a common passage and there is an encroachment of common passage. I say no. I have filed a written statement at this stage of hearing.
Municipality is not a party, my lord. There is a PR for demolition.
Page 61. Page 61. The mature stage of hearing. Suit is pending at the mature. Hearing board.
Who is for the municipality? Marshmedia municipality, somebody appears? On the last occasion also nobody appeared?
Nobody appeared.
No one.
Last time they appeared.
Who appeared?
Here.
71.
No, order name.
No one appeared, my lord, in the last occasion.
Show me the service, please. Board of Administrators, Marshmedia municipality, doesn't it have the Board of Councillors? Why
My lord,
administrators?
I'm begging apology, should be board of councillors, but applicable to
Yes.
administrators in board of administrators.
It's wrongly
Wrongly
addressed.
given, my lord. It is, name has wrongly given. Instead of councillors, it will be administrators.
But what can be done right now?
Well, what is submitting, my lord, kindly give me liberty to add board of councillors as a party respondent and to submit again upon them.
How will it help you?
Unless they appear, my lord, how they can ascertain, because it is 1048 plot number, that cannot have any premises number. They started construction since 2022, 20 and 22, did not obey the rules and regulations, and suit has been filed even only for declaration that is
Then
the court
if
passage.
your suit is there for the
Declaration.
encroachment,
For
then
declaration that it is a common passage, only declaration.
common passage is, and construction is made over the common passage.
Yes, my lord, that is
It's
given.
better you get your rights settled in the suit, because the municipality will not be in a position to.
Municipality is not a party in the suit, my lord, and no PR for demolition is there. Only for declaration, it is a common passage.
You get it declared and thereafter take subsequent steps.
No,
What
no,
can be done here?
No, municipality has a right. If when unauthorized construction is going on, my lord, the municipality should have to demolish it in accordance with law.
Prior to your declaration being obtained that it is a common passage. And tell me how you are raising the construction. Do you have a sanction plan?
Yes, that is the point, my lord.
There is a sanction plan.
Let them show, my lord, their sanction plan. Nothing is there.
No, nothing
Nothing is there, my lord. It is a common passage.
Where is the sanction plan?
My instruction is no enforcement.
Forget the instruction. You show me your sanction plan.
Nothing is there.
I have not. Earlier, I have on the sanction plan.
Where is the sanction plan?
In person to the earlier order, passed in the earlier.
No, only saying, my lord.
Inspecting officer, persons who have come to inspect.
Please come, please come.
If the sanction plan, no object, no work notice should not be given. Municipality given a stop work notice because no sanction plan was there.
The petitioner complains of illegal and unauthorized construction over RS plot number 1048 corresponding to LR plot number 1479. Ward number 7 under jurisdiction of Marshmedia municipality. Stop. According to the petitioner, the said construction is being made without obtaining any sanctioned plan from the municipality and in violation of the municipal rules. Stop. Next. The petitioner filed objection before the chairman of the municipality in September 2022 and alleges that the same has not been taken up for consideration till date. Stop. Next. From the documents annexed to the writ petition, it appears that the petitioner earlier filed a writ petition against the same private respondent, alleging illegal and unauthorized construction on premises number 29, Mohakalitala Main Road, Ward number 7, under Bashpedia municipality. Stop. The court in WPA 8326 of 2021, within bracket, Sri Sanjay Chatterjee and others versus State of West Bengal and others, passed order on 18th January 2022, directing the Bashpedia municipality to take steps in the manner as laid down in the said order. Stop. Next. The municipality has taken steps for compliance of the direction passed by the court. Stop. Next. Presently, the petitioner has came out with a separate case that construction is being made over RS plot number 1048 semicolon LR plot number 1479. Stop. Next. Learned advocate representing the petitioner seeks for a direction upon the municipality to consider the said objection. Stop. Paragraph. Learned advocate for the private respondent submits upon instruction that the municipality has already taken steps for implementation of the direction passed in the order dated 18th January 2022 in WPA 8326 of 2021. Stop. Next. The learned advocate for the private respondent has produced the notice of hearing dated 17th June 2022 and the inspection report with the sketch map dated 1st September 2022 issued by the Bashpedia municipality. Stop. Next. According to the private respondents, plot number 1048 plot number er aage RS plot number corresponding to LR plot number 1479 is the same as premises number 29 Mohakalitala Main Road. Stop. It has been submitted that as the earlier writ petition stood disposed of, accordingly, the subsequent complaint of the petitioner ought not to be entertained by the municipality. Stop. Next. None represents the Bashpedia municipality despite service, affidavit of service, and the subsequent notice by the learned advocate representing the petitioner dated 3rd May 2023 addressed to the municipality be retained with the records. Stop. Next. It appears that learned advocate representing the petitioner denies the submission of the learned advocate representing the private respondent that the plot number 1048 and the premises number 29 Mohakalitala Main Road are not the same. Stop. Next. In view of the above circumstances, the instant writ petition is disposed of by directing the Bashpedia municipality to take steps to consider and dispose of the representation filed on behalf of the petitioner, filed by the petitioner on 28th of September 2022. The procedure as laid down by the court in the order dated 18th January 2022 in WPA 8326 of 2021 shall be followed at the time of consideration of the representation filed on behalf of the petitioner. The writ petition stands disposed of.
Deeply obliged, my lord.
একটা লাইন লিখে নিন তো। The aforesaid the municipality shall take steps to conclude the matter at the earliest, but positively within a period of 4 months from the date of communication of the order. আরেকটা জিনিস, learned advocate for the petitioner is directed to forward a copy of the representation dated 28th of September 2022 and copy of the order dated 18th January 2022 in WPA 8326 of 2021 to the aforesaid respondent at the time of communicating the order of the court. Disposed.
Grateful, my lord.
My lord, I am appearing on behalf of the petitioner, my lord. This is my affidavit of service. My lord, an unauthorized construction is being made by some local persons. I do not even know exactly the names of the local persons.
You
but
don't
they
know
are,
or
no,
you don't
no,
want to
no.
disclose?
I do not, because I can see tomorrow, today, 3 persons, tomorrow 5 again new persons. So exactly, I will not be able to tell, my lord, pinpoint as to who are these persons doing exactly. But that unauthorized construction is being done without a plan, sanctioned plan.
How do you know?
That I have come to know from the concerned authorities, that without they are not having any sanctioned
me
plan.
That you have obtained instruction.
They have not, my lord, kindly, that's why, my lord, I make a innocuous prayer at this juncture. Kindly let them produce a report, my lord, in this regard.
Why?
Because they are not having any sanctioned plan, my lord.
You show me that you
I have written a
obtained
representation in this.
instruction.
I have written a representation in this regard and they have not answered to this, my lord.
Very well, but you show me that you have obtained instruction from them under the Right to Information Act that there is no
my
plan
lord,
sanction.
I did not go through by way that, because why they are making it in a wire footing basis. On a wire footing basis, they are doing so. And on any date, they will complete and they will run away from that place. And they have also started selling the portions of the flat.
And
So
still
now
you
if
don't know as to who is the person responsible
no,
for
my lord,
making
no,
construction.
no, my lord. Kindly sees, I have made a representation in this regard at page 22, my lord, kindly sees.
You stay in Kankurgachi Fulbagan.
My lord.
And all on a sudden you get to know that somewhere in the garden
I have stated, I have also stated that on oath that I visit that place for my professional, for my work. I need to go to that place.
Do you file these type of petitions against other construction works also?
No, I have not filed. This is for the first time. I go there. I have stated that on oath, my lord. At paragraph 2 and 3, my
No,
lord.
all on a sudden, your good behavior or whatever comes to the fore and you notice the unauthorized construction
It's
being
not always
made.
possible, or always I do not come to know about it. In this case, I have come to know.
Where
and
from?
that I have stated from 3 and 4 that I visit that place. It's
No,
not
no,
that
where
the place
from
is,
you came to know?
the place is unknown. And for that reason, I made a representation way back in the November 2022. And still that they have not replied to it. So, my lord, if my lord directs, subject to my lord's sanction, obviously, I think this will be very clear to my lord. Something is going, this illegal construction is going on and they are not having any plan, my
And
lord.
because you do not know as to who is making the construction, certainly you did not implead anybody as
No,
private party.
I did not.
Obviously, that is the
At
only
this
way.
juncture, no, that's why I'm saying that's at this juncture, I'm praying for a very innocuous prayer. That will not affect anybody. If a report is submitted or if my representation is considered by the municipal, that will not affect anybody.
Shall consider, Malad, he is asking for consideration, Malad. Right now I have no instruction, Malad. We shall consider and we take appropriate steps, Malad, if there is anything. Yeah, if there is at all the unauthorized construction, Malad.
Please come. The petitioner complains of illegal and unauthorized construction at premises number V-90A, comma, S.A. Faruqi Road, P.S. Rajabagan, Kolkata 700018, Ward number 139, Borough XV, under jurisdiction of the KMC. Stop. The petitioner submits that the construction is being made without obtaining any building sanction plan. Stop. Paragraph. The petitioner further submits that he is not aware as to who is responsible for making such unauthorized construction. Stop. Objection was filed by the petitioner before the corporation in November 2022. Stop. The same is yet to be disposed of. Stop. Next. Learned advocate representing the Kolkata Municipal Corporation is yet to receive instruction in the matter. Respondent number 6 will consider representation is dated 14th of November 2022. Disposed. Service taken on record.
কতদিন বললে জানো?
My lord,
Consideration.
time frame?
কতদিনের মধ্যে consider?
দিনের মধ্যে? কত?
3 months.
3 months. My lord, I am appearing on behalf of the petition.
I am appearing with Mr.
And also,
Gautam Ladi for
upgradation notice also, which last time Lordship directed me to inform them the matter being upgraded also. It starts from page.
Notice upon the private respondents. 4 and 5. Yes.
Under a series of representations being made before the respond number 1 and 2, as well as respond number 3. Your Lordship will find that annexure P6, P7, P8, P9, and P10, that starts from page 90 onwards to page 98B. The
Who is
private
Mr. Mahato representing respondent number 3?
My lord. The private respondent number 4 and 5 had made an illegal construction obstructing the common passage of the property, which your Lordship will find from the map at page 31 to this writ petition. The common passage to the two properties. They have obstructed, and the photographs also at page 99, annexure P11.
Where is your objection?
They have obstructed the common passage by raising constructing gates.
Where is your objection?
Well, these are the representations. I'll draw your Lordship's attention to annexure P6. That is at page 90. Complaint against the private residence 4 and 5 by the petitioner before the councillor of ward number 4 on 14th of January 2020. Translated at version is at page 91A.
Page 90 is addressed to the councillor.
Yes, madam.
Councillor is not the appropriate authority to take a decision.
Then, my lord, again at annexure P7 at page 92. The translate version at page 92A. Similar complaint that they have obstructed the common passage, completely blocking my common passage so that I cannot access my septic tank.
Why don't you approach the civil court for remedy?
Yes. They have made illegal construction. That will take a long period of time. Civil suit, filing a civil suit is illegal construction. They cannot. This is the common passage of the property.
You say it is
The
common.
municipality authorities once went down there to inspect the property in September 2022. What happened, resulting they went down to make an inspection, and the private respondent registered an FIR against the petitioner.
You say it's a common passage.
My lord,
Your contention is disputed by the private respondent.
not only my property, not only the property of the private respondent, there are other residents of the building also.
It is you who have filed this writ petition.
Yes, my lord.
You say it is a common passage.
My lord.
Your contention is opposed by the private respondent. What is to be done?
Well, my lord, kindly look at the my prayer portion, page 13.
What is there?
Why don't we kindly look at page 13 of my prayer portion, 13 and 14, prayer A and B.
What have you prayed?
For demolition of illegal structure.
Commanding the respondent on the writ in the nature of mandamus, we should commanding the respondent numbers 1 and 2 by taking assistance of the respondent number 3 to immediately take adequate steps demolishing the illegal structures, blocking the common passage of the property in question, writ petitioners and the other owners at Borobagan Lane, Police Station, Srirampur, District Hooghly, Kolkata 7 lakh.
Please wait. Private respondent, what is your submission?
My submission is, my lord, first submission is that the board of councillors have not been made parties. Only
Yes.
the chairman has been made. An executive officer has not been made. My lord will kindly come to page 92, my lord. There is no single line subject to correction, my lord, that I have made any illegal construction on the passage.
Are you making construction?
No, I am not making construction, my lord. This is a purely private dispute, and my lord, so far as my case is also that it's a common passage, but I am not making any construction on the.
Nobody is raising construction.
My lord,
It's a
again,
fact litigation.
allegation relating to the police, my lord, FIR has been registered and.
No, FIR is already, but is
My
there,
lord, charge sheet has been submitted.
no, is there any iota of proof to show that any construction is going on?
Page 99, annexure P11, my lord. Page 99, 102.
আমাদের বলতে বলবো এইটাই বলবো কোর্টের অর্ডারটা
Charge sheet against the petitioner.
সিভিল ডিসপিউট হ্যাঁ ও যা বলে দিচ্ছি
এইটা তো অ্যান্টিসিপেটরি বেল।
হ্যাঁ বেলের সময় ওটা তো সিভিল ডিসপিউট you admitted.
We have disclosed that in the writ petition, my lord,
What?
that we obtained even anticipatory bail in respect of the.
No,
And it is civil dispute is
what is this?
Position they have admitted in the writ petition that no, there is no construction, only iron gate has been installed.
আরে সেটা
Now, if the iron gate is installed, the Srirampur municipality will go and to remove the iron gate, and they're making the whole matter unauthorized construction.
Let me show iron gate.
My lord, annexure P11, my lord.
Paragraph 1, my lord. Of the very writ
Of the
petition, page 1, paragraph 1.
Photographs annexure P11 from page 99 onwards. 99 to 102.
Demolition, paragraph 1, to demolition certain illegal construction made by the private party illegally blocking the project, that is the contention. But in the writ petition and the annexure in the representation, they have been made the iron gate.
Iron gate in the house, my lord.
not in this.
This is the same house.
Common passage, my lord.
But this is the private dispute, go to the court before the civil court.
Civil suit.
And for a second
Once look to
injunction.
Prayer B of my writ petition, my lord. Prayer B of my writ petition.
Page
The petitioner alleges illegal and unauthorized construction at the instance of the private respondents over the common passage of the property by making illegal construction of gates, walls, and iron grills Stop. Next. Learned advocate representing the private respondents denies the aforesaid submission. It has been submitted that the grills have been placed over the private property of the private respondents. Stop. No construction in any manner whatsoever has been made over the common passage as alleged or at all. Stop. Next. The learned advocate representing the municipality submits that it is not possible for the municipality to enter into or decide any private dispute in between the parties. Stop. Next. The officer in charge. No, not officer. Inspector in charge, Srirampur Police Station, Chandannagar Police Commissionerate, has filed a report before this court signed on 6th February 2023, wherefrom it appears that in response to the complaint lodged, the police have taken steps and has submitted charge sheet against the petitioner Mita Bokshi and her husband Shubhra Kanti Bokshi. Stop. Next. From the submissions made on behalf of all the parties and upon perusal of the materials on record, it appears that there are several private disputes in between the parties. Stop. The municipality will not be the competent authority to decide or adjudicate any private dispute in between the parties. Stop. It will be open for the aggrieved party to approach the appropriate civil forum for declaration of private rights. Stop. No relief can be granted to the writ petitioner in the instant case. The writ petition fails and is hereby dismissed. The report of the police be retained with the records.
I served a notice to all the parties. The private dispute for making the unauthorized construction encroaching my petitioner's property.
Encroaching the petitioner's property.
Private respondents are making the illegal construction PM, my lord. My lord, they demolish the partial demolition boundary work and also to clean the bond, which is very about 1 meter. My lord, I approached before they have asked to bring the course order without my lord. Can you see my representation? Page 24, my lord.
Is anybody representing the private respondents? Boshirat Municipality. There is a civil suit pending in between you and the private respondent. Why are you here? There is an order passed directing maintenance of status quo with regard to the nature, character, and possession of the suit property. Why are you here?
But they are still construction. But
the court is open. Why don't you approach the court for relief?
Without sanction plan, they are constructing.
Illegal construction. But the construction is over a private property.
They are also encroaching my property.
Yes, encroachment, the civil court will decide.
They demolished my boundary wall.
It's a very good reason for bringing this to the notice of the court below.
I am praying for kindly direct for
No inquiry report. পৌর আইন অমান্য করিয়া রাতারাতি বহুতল বাড়ি নির্মাণ করছে? How can it be done? Overnight, multi-storied building, can it be done?
They are every day, my lord,
ছাড়া আমার বাড়ি ঘর তফসিলাতে ইত্যাদি ভাগ আছে। আমি বাধ্য হইলাম। Please come. The petitioner complains that the private respondents are raising construction without obtaining any sanction plan. Stop. Complaint filed before the Boshirat municipality is pending consideration. Stop. None represents the municipality or the private respondents. Stop. Affidavit of service is taken on record. Stop. From the documents annexed to the writ petition, it appears that a civil suit is pending consideration in respect of the self-same property, and an order of injunction has been passed directing the parties to maintain status quo with regard to the nature, character, and possession of the suit property. Stop. Next. In the absence of the municipality, it will not be possible for this court to decide the issue conclusively. Stop. In view of the above, the instant writ petition is disposed of by directing the Board of Councillors, Boshirat Municipality, to take into consideration the objection filed by the petitioner, alleging unauthorized construction. In accordance with law, after giving reasonable opportunity of hearing to all the necessary parties. Stop. A spot inspection shall be conducted to ascertain the nature and extent of unauthorized construction. তারপর in the event বলে আমাদের usual order আছে, ওটা দিয়ে দেবেন তো। Writ petition disposed of. Board of Councillors, আচ্ছা একটা কাজ করুন, respondent number 2 করবে, and the representation is dated 6th of January 2023. The report filed by the police is taken on record.
I appear for the Garudia municipality.
But I am appearing for the petition. On this matter, my lord, I am the wife. My father-in-law had some certain properties. My husband had inherited certain such properties, and he was also gifted certain property, the same property, a share of it. My lord, my husband had, by a registered gift deed, had transferred the property in my name, wife, and his minor son. Thereafter, I had prayed for mutation, which has not been done. But I'm only praying for consideration of my last representation, which is at page 56.
Supply of chain deeds.
My lord, what happened, my lord? I said initially my husband became the owner of the property because it
No,
was.
but then why will the chain deeds be supplied by the municipality? You cannot.
My lord, no, I was asked by me to be supplied by me, my lord. The language is difficult, my lord. I have annexed which are the gift deeds, my lord. I had been gifted, and my husband had also been gifted a portion. He had inherited certain portion, and he was gifted certain portion of the same property. My lord, I have annexed those annexures.
Where is the application for mutation?
My lord, kindly come to page 55.
Yes.
Now, this is the receipt voucher, my lord, where I had.
Where is the application?
My application is not recorded. Possibly, my lord, application was filed and no copy was taken. But the receipt.
What is page 54? Check up.
I tendered apology, my lord. I tendered apology, my lord.
Well, the first application was on 53, 2018.
There's a difference in the, my lord, description of the property features. But kindly come to page 18 and page of the chain deed, page 40.
Page 18.
Yes, ma'am. Last portion, Sampati Chohati. Nilmani
Yes.
Nath or
Why don't
Shikhanath.
you intimate the petitioner what are the deficiencies?
No, I think they have done because the note sheet says that they have referred it. Because of the difference in the chain deed and the original gift deed as claimed by the petitioner. Well, I'll advise them to have a hearing done and thereafter decide.
Yes, whatever is required to be done, let the petitioner know that these are the documents he or she is required to file. Then do it. Either allow or reject, do whatever.
As your lordship.
Isn't it? What is the use of keeping it pending? This has been sent for legal advice, so no. Please come. The petitioner's prayer for mutation is pending consideration at the end of the Garulia municipality. Stop. Next. Learned advocate representing the municipality submits upon instruction that there were discrepancies in the description of the property as submitted in the application and the chain deeds. Stop. The petitioner was intimated to provide necessary documents to process the application for mutation. Stop. Next. From the documents annexed to the writ petition and the submissions made on behalf of both the parties, the present writ petition is disposed of by directing the municipality to intimate in writing the deficiencies in the application for mutation filed by the petitioner. Stop. The petitioner will be obliged to, the petitioners will be obliged to rectify the defects and give proper description of the property so that the application for mutation can be processed by the municipality. Stop. Next. Learned advocate for the petitioner is directed to forward a copy of the application for mutation, document showing submission of mutation fees, the chain deeds and all other necessary documents in relation to the subject property to the municipality at the earliest. Stop. The municipality shall, upon consideration of the aforesaid documents, intimate the petitioners the formalities to be complied with for processing the application for mutation. Stop. Next. The municipality shall take steps to conclude the matter at the earliest, but positively within a period of 12 weeks from the date of receipt of all documents from the petitioner. Writ petition disposed.
May I take back the note
You
sheet?
can take back the note sheet.
I'm deeply aware. Thank you.
May I please, your lordship? I beg to appear on behalf of the petitioner, your lordship. This writ petition has been filed to consider my representation for supplying of filtered water to the premises of the petitioners, your lordship.
Which authority?
AMC authority, Kolkata Municipal Corporation. The premises,
Where is your application?
my application is at page 103. It starts at page 103.
Are you the owner of the premises?
I am the legal heir of the Thika tenant of the premises, your lordship.
Is there any other water connection in the premises?
There is no water connection.
No filter water connection.
No
Yours
filter
is the only application that has been made to obtain filter water.
Yes,
Where is your application? It has to be filed through the licensed plumber. Has it been done?
I have made a representation, your
No,
lordship.
no, representation will not do. There is a formality which is to be complied with.
We are, there's a pending proceeding before the Tika controller. Where we have applied to get our names mutated as Tika tenants, currently the Tika tenants.
In whose name is the property recorded right now?
Right now, in the name of Sumati Baladasi.
Who is she?
She is the original Tika tenant, your lordship. The original Tika tenant. I have annexed all the.
Is she there or she has expired?
She has expired, your lordship.
She has expired.
Expired. Thereafter, we have applied to the Tika controller to get our names mutated. Now, in the meantime, we had made this representation, but it was not considered, your lordship. Citing the pendency of this Tika application, they are not providing us the filtered water, your
But
lordship.
then if you are, suppose the proceeding before the Tika goes against you, then what will happen?
Your lordship, if your lordship may kindly consider page 86, this is a report submitted by the Narkaldanga regional office of the Tika controller. In this particular report, if your lordship kindly comes to the middle portion, there it is recorded that IB copy in the year 2004-5, 1992-93, 97-94, 74-75 from the KMC authority has been received by the office. Here it has been stated that from the IB copy in the year 1974-75, it is obtained that the premises number 121 by 4L has been let out to one Shumati Baladasi for an area of such and such, which may kindly be seen. So my possession is also recorded in this particular report, which has been submitted by the Narkaldanga Tika office. Even if I am a judge that I will not be a Tika tenant, your lordship, but I am an occupier for a long time, I am in long possession, I am praying for a supply of water, drinking water, your lordship.
Corporation.
I have got a report, it says my lord that there exists one deep well in the.
There is one
deep well.
Deep well.
And my lord, now the corporation has introduced my lord online mode to apply the new filtered water connection.
So the petitioner can apply online.
So far as the petition is difficult is this, that so far as the premises is concerned, my lord, there is no name against these particular premises on our record. And there is no SSC number also. Therefore, my lord, if he my lord, approaches to us, because I find, my lord, he has not yet taken any step on mutation. I do not know what is his status at the present moment. And nobody's name against the particular premises. You logically see they have got given the assessment record also. That shows but nothing.
Don't you pay tax?
So it is still pending. I have letters annexed where we have asked the KMC authorities to intimate us regarding the dues and the payment of taxes. It has still not been reverted to us. They have still not reverted back.
What his name is found my lord against these particular premises, no SSC number is
How
there.
can this be?
I have
A
got
premises is
electricity
there and you do not assess it.
My lord,
A premises is there and you do not assess it.
at one point that time could we have been there were the chronological my lord, the status my lord, his in possession.
Is all right. It's a different thing, but filter water connection is something different.
Well, my lord, could also be used for water
No.
for supply of water for that for one point of time. Now we have
Drinking
introduced
water.
right now.
Drinking water.
We have drinking water from the deep well, my lord, used to be consumed.
No, that is history.
But now, my lord, now we have introduced at that particular premise, particular, my lord, the area, the filter water.
Filter water connection.
At the present moment. That is the reason I'm submitting, my lord. He could have applied, but the thing is this, my lord, his name is not on a record.
Without the SSC number, it is not possible.
Here to it.
But lordship, from the IB records of the KMC itself, it shows that we are in long possession from the 1974-75 IB records at page 86. This is the report submitted by the regional Tika
Narkaldanga Regional Thika Office.
Have you obtained the IB report copy? Where is this copy?
The IB report,
Is
they can
available to the
produce it.
corporation.
They can produce a, they can produce
They
a
can
report.
produce is a different thing. It is your case. You should come up with all documents. You had this within your knowledge that in the IB it is there. You ought to have obtained that IB report from the corporation and annexed it with the writ petition.
Then I crave leave to just for a few weeks, then I will get the IB copy and I will supply it in a supplementary affidavit, Your Lordship.
Page 86,
Page 86.
last paragraph. Will you take further instruction? Please come. The petitioner's application for obtaining new filter water connection from the Kolkata Municipal Corporation. Achha, filter water connection for domestic purpose from the Kolkata Municipal Corporation is pending consideration. Stop. Next. The petitioner claims to be the heirs of the recorded Thika tenant. Stop. Next. The process of declaration of Thika tenants by the Controller Kolkata Thika tenancy is pending consideration. Stop. Next. Learned advocate representing the Kolkata Municipal Corporation produces report from the executive engineer within brackets Central Water Supply Department KMC signed on 15th May 2023, wherein it has been mentioned that the property in question was inspected and it was observed that there exists one deep well. Stop. As there is no SSC number against the subject premises, the application of the petitioner seeking new filter water connection for domestic purpose cannot be entertained. Stop. The petitioner refers to a document at page 86 of the writ petition. Allegedly issued by the Special Revenue Officer, Grade 2, Kolkata Thika Tenancy. Dated.
Lordship, it would be officer in charge, Narkaldanga Regional Office, that he has submitted the inquiry report. It's at page 84, recorded in the order sheet. That is the this report has been submitted by the officer in charge, Your Lordship.
Has referred to a document. Referred to the inquiry report by the officer in charge, Narkaldanga Regional Office, Kolkata Thika Tenancy, wherein it has been mentioned that the petitioners are the legal heirs of the returnee, Shumati Dasi, and they reside over the said premises. Reside over now to have a reside at the subject premises. The same is also evident from the recording maintained by the recording in the inspection book of the Kolkata Municipal Corporation. Stop. Next. Learned advocate representing the Kolkata Municipal Corporation is directed to produce a copy of the produce a photocopy of the inspection book of the year 1974-75. As mentioned in page 86 of the writ petition. Stop. Let the same be produced before this court on (29th of June).
When I see at page 85, I find one of the in the proceeding before their authority, the such amount of documents were produced by the Kolkata Municipal Corporation, but there are some of the confusion is there. That is that has been noted in it at page 85.
Yes.
Kolkata Municipal Corporation has sent the IB copy of 3rd quarter 1980 in premises number 121-4L Maniktola Main Road, and IB copies 3rd quarter 1992 and 3rd quarter 2013-14 in premises number 121/4L/1 in respect of defined necessity, but did not clarify whether the premises number 121/4L/1 Maniktola Main Road was renumbered from entire.
So it is for your authority
I
to.
want to take regard to this.
I'm grateful, Your Lordship.
Maybe that premises number is not here. The separate
Maybe it has been renumbered. That is the reason you cannot get.
document also to be considered whether that particular premises or the my number.
Yes. Affidavit of service taken on record.
I'm grateful, Your Lordship.
I paid for the petition. This is my affidavit of service.
Yes.
The material respondent at Kolkata Municipal Corporation, to whom notice of upgradation was also served. Sir, are you appearing?
I have not got any notice of upgradation. Anyway, you want to do it.
Is there any private respondent?
Yes, Your Lordship, but they have been served. At the time after filing of this petition, I have served
Not
them.
filing, because your learned friend says that the notice of upgradation was not received by.
Not objecting, but whether the private respondents got it.
No, upon private respondents, notice of upgradation is not
Then
served.
how can you move?
But the writ petition I have served, Your Lordship. It is
Service is not the everything. The matter was appearing at the bottom of the list.
Your Lordship, otherwise the private respondents are not material, because my main grievance is.
Delete their name.
Your Lordship,
Court will take up the matter.
Your Lordship, they are the borrowers. If Your Lordship wants, I can serve and come back. I have no objection to that. If Your Lordship wants, I can serve and come back.
The matter was appearing in the
Sir, দুটো মামলা আলাদা আছে।
combined monthly list. Stop.
That I have
The
understood, but
same has been upgraded, citing urgency by the learned advocate representing the petitioner. Stop. Notice of upgradation has not been issued.
there you have not
Stop. Learned advocate representing the Kolkata Municipal Corporation is present, but none represents the private respondents. Stop. Let notice be served upon the non-appearing respondents. List in the combined monthly list of July.
Your Lordship, a week's, Your Lordship, kindly, no, not, Your Lordship, kindly, a week's time only, I will serve and come back.
My lord, one thing, my lord. My lord,
Name
one
order.
thing. My lord, I am assisting Mr. Mukherjee. My name also be recorded for KMC.
Which item?
My lord, 158 and 159.
he is my junior in both the matters.
Both the matters.
Your Lordship,
Recorded.
if it is kept in monthly list, Your Lordship, again it will go. Kindly, a week's time, kindly grant me, I will again serve and come back.
I know you can do it within a day also, but then the court will not permit.
In 159, I am also appearing for the petition.
Same thing.
Same order. Distress warrant.
So, my lord, Municipality.
Who has not accepted?
But I am appearing on behalf of municipality.
Who has not accepted?
Municipality refused.
Which municipality?
Kalna municipality, but when I catch hold of the learned council of the municipality.
Oh, you are there?
Yes.
But I am
This is the
Then
evidence service.
please don't file those copies.
No, my lord,
It will add up to the volume of the papers over here, nothing else.
my lord, evidence service be kept on record.
Hey, Kalla municipality, record his name.
No, my lord, what happened in this matter? My lord, a tender was floated, my lord, for the ferry, for ferry ghat. No, my lord, I was participating in that tender, selected, and agreement was executed. My lord, kindly come to page 25 of the writ petition.
Yes.
My lord, this period of the agreement was 3 years, from 16 February 2014 to 15 February 2017. And another relevant portion of this agreement I just want to show. As well as the security money deposited, 5 lakhs rupees. The yearly tender amount, the lease amount is 30 lakhs, 5,000 rupees.
When was the last lease?
Lease expiring, is supposed to expire on 15th of February 2017. Now, my lord, in the meantime, if the municipality want to terminate the lease agreement.
No, that period is over. Now, what is the
Yes,
immediate
my lord,
cause
I'm
of
just
action?
coming, my lord, because this agreement.
Just coming will take time. Please,
My
be
lord,
fast.
this is as per this agreement, if they want to terminate the lease, they have to give us a show cause and a
Yes,
procedure.
that is
Now, my
over.
lord, what happened in May 2016, just 3 months of my third year lease, my lord, incident what happened, our boat was capsized, some people were died. Now, my lord, without any proceeding, without any show cause, they terminated my lease agreement. A criminal proceeding was initiated. In the criminal proceeding, my lord, it was found that I was not at all responsible for the incident happened, because this is the overcrowded, due to the overcrowd, my lord, this was happened. Now, my lord, thereafter, I made several representation for refund of the money for 9-month period, which is, my lord, not utilized by the lessee. This is amounting to 22 lakhs, as well as, my lord, the security deposit 5 lakhs rupees that I pay for refund. This is the representation, my lord, find at page 68.
You want 68 to be considered?
Well, there is no question of any consideration, because as per this agreement, I'm entitled for refund of 9th month, because as per agreement, I have to pay the advance. 30
Tell
lakhs
me
rupees.
one thing, what were you doing from 16 till 2022?
My lord, I have stated, my lord, because I've stated that. Because until and unless I have been released from the criminal proceeding, my lord, I can't approach for that. Though, my lord, I made a representation, several representation made, even, my lord, from 2016 onwards. First representation made 24th of August 2016. And, my lord, the criminal proceeding, the criminal court verdict comes on 29th November 2022. And the finding of the criminal court that I am not at all responsible for this incident. And it is also admitted in the proceeding, my lord, that there is no show cause notice. Nothing was issued for before termination. It's an unilateral termination of the lease deed. I'm just.
Please come. Municipality, do you have any instruction?
My lord,
No.
I have got an instruction, but frankly
Not very-
speaking, my lord, this is not satisfactory. My
Very
lord.
good.
Lordship, what?
Petitioner is aggrieved by the act of the Kalla municipality in terminating the lease of the ferry service way back in 2016. Stop. The period for which the lease was effective is from 16th February 2014 to 15th February 2017. Stop. The petitioner's lease period was abruptly terminated on
31 page 56.
on
Page 56, my lord.
31st May 2016.
31st May 2016.
31st May 2016. Stop. It appears that the petitioner was implicated in a criminal case and was taken in custody. Stop. The said criminal case came to an end in the year 2022.
November 2022.
In November 2022. Stop. The petitioner thereafter filed application seeking refund of the payment for the balance period of the lease period and the security deposit. Stop. The said application was made in January 2022 and the same is pending consideration till date. Stop. Next. Learned advocate representing the municipality is yet to receive proper instruction in the matter. Stop. Next.
Instruction, my lord, what?
Proper instruction is not there. Next. In view of the above, the instant writ petition is disposed of by directing the chairman of the municipality. Will it be the chairman or the board of councillors?
I'm the chairman, but
Chairman, Kalna municipality to take a decision with regard to the prayer submitted by the petitioner on 18th January 2022 in accordance with law and in terms of the lease agreement entered in between the parties after giving reasonable opportunity of hearing to all the necessary parties and to pass a reasoned order positively at the earliest, but positively within a period of 12 weeks from the date of communication of this order. The learned advocate for the petitioner is directed to forward a copy of the representation dated 18th January 2022, along with all documents in support of his claim to the chairman of the municipality at the time of communicating the order of the court. Stop. Next. It is made clear that this court has not entered into the merits of the claim, paragraph 37. Writ petition disposed of.
My lord, the representation dated, last representation I filed there 15th March 2023.
So what? His earlier one is also pending.
great from.
Yes.
Yes.
Lordship, I'm appearing on behalf of the petitioner, Lordship.
Yes, what is the matter?
Lordship, this writ petition has been filed requesting the Kolkata Municipal Corporation to remove padlocks from my property that has been unauthorizedly put up without serving any notice or any intimation whatsoever, Lordship. Lordship, what happened is I became the owner of the part of the whole premises in 2010 by the decree from the learned Alipur court. Subsequent to that, Lordship, I wanted to mute it, muted the portion in my name, and I approached the municipality and I made my mutation application. A huge tax amount was due because of the pendency of the civil suit. So I was advised by the municipality to pay the tax, and I requested for the assessment. Several communications occurred between the parties. The hearing was also fixed up, but no order was passed. Several dates hearing were taken up, but no order of the hearing was passed. And my application, suddenly I came to know from the online portal that my application was rejected. My application for mutation was rejected. At that point of time, the outstanding due was about 29 lakh rupees, 13,322, Lordship. After my application was rejected, I reapplied for mutation procedure. When I went for the reapplication, they told me to submit an ad hoc amount in lieu of the due amount, so that they can process my application. Accordingly, I submitted an amount of rupees 22 lakhs on an ad hoc basis, as I admittedly said. Thereafter, my mutation was also granted. Now, Lordship, suddenly in the year 2022, Lordship kindly comes to page number 41, Lordship. Suddenly on 3/6/2022, Lordship, I received this letter of intimation stating that an outstanding amount of rupees 80,24,171 is due. I have no idea how this has been received. I am only occupier and I'm owner only a part of the whole premises. This says even Lordship, this share says that it is a consolidated on the second column, Lordship. Consolidated. It is not about my portion. There has been no breakup shown as to what is my due. And 80 lakhs amount is due, Lordship. Now, Lordship, subsequently, thereafter, but it has been issued in my name, Lordship. Thereafter, Lordship, on page 44, Lordship, suddenly I received that there is an outstanding amount of 80 lakhs 22,000. Lordship, one thing, thereafter I served a legal notice asking for having a hearing so that this can. But Lordship, surprisingly, this particular notice dated 7/6 and also this 3/6 notice has been sent to this address at 20 Deoda Street. This is a very old address, Lordship. Even the I had intimated my current address to the municipality as well. All the hearing notices when prior to this application, Lordship, when my mutation application hearing was going on, all the notices were served upon the correct address, Lordship. If you will kindly see, Lordship, page 33. 34.
When was the padlock put?
For Lordship, padlock was put on 10th of January, Lordship. 10th of January. And Lordship, I have my guard intimated this whole incident to me way later than this, Lordship, because all these communications that had been sent was sent to my old address, Lordship. Even if there has been sent some, I only received a copy of this intimation letter and a letter to and this immediate payment of outstanding, and nothing else I have received, Lordship. And suddenly all my floors, 2 floors have been padlocked, Lordship.
Page 43, I see a letter of intimation.
Lordship.
3rd of June 2022.
Yes, Lordship.
You could have produced documents in support of your claim. This could have been done.
Lordship, I have not received this letter, Lordship. I received this letter was sent to my 20 Deoda Street address, Lordship. It's a very old address, Lordship. I do not say that there is no one in this address, Lordship. Even, Lordship, communications were made to my new address before on the hearing as well, Lordship.
Let me hear.
Well, the demand is in respect of the premises number 56/2, Hajara Road. There are 2 owners. One is Misri Lal, another is Bhola Prasad Shaw. Misri Lal Shaw, Bhola Prasad Shaw. Misri Lal died. In his place, this Rupesh Shaw has stepped into the shoes of Misri Lal Shaw, owning half of the entire property. Litigations before Alipur court is there. Ultimately, my lord, it was share of tax was apportioned. If your lordship comes to page 41, your lordship would find there are 2 addresses. One is Deodar Street and other is 56/2 Hajara Road. As rightly fell from your lordship, we first asked, at that juncture on 3/6/22, the person concerned had all the liberty to raise objection. Valuation is not in dispute. Valuation accepted. Then no communication so far as all these are concerned. The dues are 80 lakhs somewhat. Paid only 22, which is in our record. Now, today the current dues would be, this is March 2023, the principal amount along with the interest would be around 77 lakhs 99,000.
It has come down from 80?
Because some payment was made, 22 lakhs. Thereafter, in the interregnum, the
interest and
balance
penalty.
What was with us, on that again interest. Now it has now come to Sorry, my lord, we have received 22 lakhs, but it has not been adjusted as yet. Then, my lord, we proceeded in terms of section 219 and 220. This is where it stands.
There is a representation pending. I see at page 45. Can this be considered? Consider and take.
Lordship,
Your
also,
lordship directs.
Lordship, we have never accepted the valuation, Lordship. The moment we received this communication from our older address, Lordship, we have immediately moved through the legal advisor of my.
Not the way to challenge evaluation.
Lordship, you have to approach the appropriate forum.
By that time, Lordship, it was already 20, almost
Then
7,
what
8
can
months
be
had
done
passed in, Lordship.
If your person communicates to you at a delayed point of time, the corporation cannot be held to be responsible,
Lordship,
isn't
the
it?
address, it was never sent to the premises, Lordship. No notice, nothing was sent to the premises, Lordship. It was only sent to that address where I
If
was
the
earlier
mailing
sent.
address is different, what will the corporation do?
Lordship, the corporation.
Achha. The matter relates to the premises number 56/2 Hajra Road. Stop. The petitioner is the co-owner of the subject premises. Stop. It appears that a considerable sum is due and pending on account of property tax in respect of the petitioner's share in the property. Stop. Letter of intimation dated 3rd June 2022 was served. But as the payment was not made in accordance with the said letter of intimation, comma, the corporation has presently put padlock on the subject property. Stop. On 7th June 2022, notice was served for immediate payment of the outstanding dues to the tune of rupees 80 lakh and odd. Stop. The petitioner raised objection through the learned counsel in January 2023 and alleges that the same is pending consideration till date. Stop. Next. Paragraph: learned advocate representing the corporation submits that there is a provision for filing objection within 15 days from the date of receipt of the letter of intimation. Stop. The petitioner failed to file the objection within the stipulated time period. Stop. Next. Be that as it may, as it appears that an objection was filed on behalf of the petitioner in January 2023 and the same is pending consideration till date. Accordingly, the instant writ petition is disposed of by directing the
Manager
is not there. Chief manager
or assessor collector south.
assessing officer, I do not think there is any
There's
assessing
nothing
officer.
called assessing officer. The person concerned had not at all
Been made as
array of
party.
respondents, either assessor collector south or chief manager revenue south. Let her add here and now, amending the cost title, your lordship directs either of them.
By directing the assessor collector within brackets South Kolkata Municipal Corporation to take into consideration the objection filed on behalf of the petitioner in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties, and to pass a reasoned order at the earliest, but positively within a period of 12 weeks from the date of communication of this order. The reasoned order shall be communicated to the petitioner immediately thereafter. Stop. It is made clear that this court has not entered into the merits of the claim of the petitioner. Paragraph টা add up করে দেবেন. Learned advocate for the petitioner is directed to forward a copy of the objection dated 30th January 2023.
That is also the wrong name.
Comma, the letter of intimation dated 3rd June 2022. The notice for immediate payment of outstanding dues dated 7th June 2022, and all other documents in support of the claim to the aforesaid respondent at the time of communicating the order of the court. একদম গোড়ার দিকে add করুন. Leave granted to the learned advocate on record of the petitioner to implead the assessor collector within brackets South Kolkata Municipal Corporation as party respondent in the instant writ petition. Stop. The formality of serving a copy of the writ petition upon the added respondent stands dispensed with, as learned advocate has already entered appearance on behalf of the Kolkata Municipal Corporation in the instant writ petition. The page 45, there is a seal, and it is clearly mentioned Office of the Assessor Collector South. You did not implead the authority as party. Disposed.
My lord,
Grateful, Lordship.
my lord, one thing, my lord. My lord, one thing, my lord, I am also appealing for the claims.
Mr. Dey still is there with you?
Yes, he's not.
Lordship, one indulgence, Lordship. The outstanding amount is increasing each day, Lordship.
It is.
If kindly, Lordship,
You submit the documents immediately. 1 year has already elapsed from June 22 to June 23. You could have
Lordship,
approached earlier.
Lordship, if an order can be passed to that, to keep it to this, Lordship, and the hearing be
No,
done.
how can that be?
With
There is
changes
no
to the
law.
time, every 3 years, 3 months, it will be again recalculated.
There is no law.
My lord, my name is recorded, my lord.
Yes, your name will be recorded, Mr. Dey.
Obliged, my lord.
So this is my application. This is the epidemic of service. I have all the response. So this is very unfortunate case. This is the second time litigation. Although the petitioner retired in the year 2019, my lord, the pensionary benefit has not been given. PP has not been issued. Earlier occasion, the
Who
petitioner
was the employer?
employ, my lord, the Jiagonj municipality. Earlier occasion, I moved a writ petition, and in terms of the writ petition, my lord, the written order was passed by the, my lord, the director of pension. This is, my lord, your lordship, kindly see, my lord, the page 47. And they sanction there, my lord, page 47. It appears from the written statement made by the municipality that the service of the petition was regularized on and from the service of the petitioner was casual in the nature prior to such and reflected from the submitted accuracy roll attendance registered. And the order is considering the facts as stated above. I am
The date of this order.
My lord.
Date of this order.
The order passed, my lord, regional order, my lord. Regional order
It's in
passed.
order page 47. What is the date?
Page, my lord, 48, 8th August 2022.
Communicated 8th August 2022. Thereafter, what happened?
Thereafter, my lord, the municipality submitted, my lord, the letter, my lord, page 50, my lord, asking the post facto approval, my lord. Thereafter, they submitted and the objection was raised by page 49. The duly authentic, page 49 is the objection made by the, my lord, the director. Duly authenticated copy of the approval of appointment from DLB. And to that extent, my lord, the municipality already submitted page 50, the proposal requesting to sanction the post facto approval. Till date, my lord, nothing has been done. So the TP has not been issued on the sole ground. Page 50 on the undersigned would like to request you kindly to extend post facto.
Mr. Mahato.
Within 3 months.
What within 3 months?
Within 3 months, my lord, everything will be completed.
I will record this order provided an affidavit comes from your client.
Affidavit?
Let this time period that everything will be done within 3 months be filed by way of a written affidavit. Report by way of affidavit. Otherwise, you do not take the responsibility. Your client will not act.
In one matter, my client did not act. That does not mean that, my lord, every time my client will.
Nobody knows. Why will you take the responsibility?
My lord.
It is better
My lord.
the authority come up and say that we will do it.
My lord.
Please come. The petitioner is a retired employee of Jiaganj, Azimganj municipality. Stop. Next. The director, pension, provident fund and group insurances. In compliance of the direction passed by this court in WPA 14995 of 2021, within bracket Shomir Khan versus State of West Bengal and others, passed order that the petitioner is entitled to receive pension. Stop. The pension sanctioning authority, that is the chairperson, Jiaganj, Azimganj municipality, was directed to accord sanction for pensionary benefit in favor of the petitioner. Stop. Not stop. And was directed to send all the relevant papers to the DPPG within 2 weeks. The assistant director DPPG was to audit the papers and if found satisfactory to issue the pension payment order. Stop. The assistant director returned the papers. Now, returned the pension case to the chairman for clearing the defects as mentioned. Stop. The chairman of the municipality, after clearance of the defects, forwarded all papers to the director, director of local bodies on 9th September 2022. Stop. Paragraph. The petitioner alleges that after submission of papers by the municipality, the director, Directorate of Pension, Provident Fund and Group Insurance have not taken any further steps in the matter. Stop. Next. Learned advocate representing the DPPG submit that necessary steps shall be taken.
And also director of local body. Usually the director of local bodies.
In the matter. Stop. Next. The
Mr. Mahato also appearing on behalf of the director of local body.
No, I know.
As well
But
as
then DLP does not have any role right now. It is the DPPG.
Yes.
Let a report by way of affidavit be filed by the director, Directorate of Pension, Provident Fund and Group Insurance, clearly mentioning as to why the pension payment order has not been issued in favor of the petitioner till date. Stop. Defects, if any, which is to be required to be cured, shall also be mentioned. Stop. Next. The report by way of affidavit shall be prepared and served upon the learned advocates appearing on behalf of the petitioner and the municipality by 30th of June. Exception, if any, be filed by 7th of July. List on 12th July 2023, marked for orders. Acha, pendency of the writ petition will not stand in the way of the DPPG to issue the pension payment order in the event all documents of the petitioner are in order.
The next one, both sides are there. Next one, my lord.
Both sides are
Yes,
here.
yes.
How long will it take?
It's short matter, short matter.
Short matter.
Pensionary benefit.
What? Pension not being paid?
No, pension and gratuity. Payment has been made, my lord, but.
Part payment paid?
Yes, my lord. Gratuity and pension, my lord, retired, my lord, in 2020.
Hmm.
Pension payment order issued on 24th of August 2020. 3,65,000 was the gratuity amount. Thereafter, my lord, revision of gratuity, my lord, was made. Your lordship kindly comes to page 70.
Yes.
So, my lord, the gratuity in 2019, 3,65,000 at the bottom. And, my lord, that has been revised, 4,71,675. And the pension, basic pension and revision of pension was also made. Now, my lord, the arrear gratuity and the revision and the arrear pension to be paid with interest.
Arrear gratuity and arrear pension.
Arrear pension, revised pension.
Arrear revised pension and arrear revised gratuity also.
Yes. Arrear revised gratuity also.
Gratuity has been paid.
In terms of
4,71,000 milord is the revised gratuity as
One
per
minute.
ROPA 2019.
ROPA 19.
Now, milord, they have totally paid 1 lakh till now.
Why? Chandanagar Municipal Corporation, no fund.
My lord, there is some shortage of funds.
There-
Now?
COVID.
This is a
Now, my lord, they are paying one by one, my lord, and on instruction, I am saying, my lord, he'll be paid very soon, my lord.
Soon means
Not
3 months.
3 months. But
Very
1 month, more, 4 months, my lord.
4 months.
Chandanagar Corporation, Lord, is now rich, Lord. They have,
Rich, na?
they
Not-
have
not now.
Yes.
good funds.
No, it
They're
has
running
got a lot
free
of
service
funds.
and yes.
French funds are coming.
Yes.
Petitioner is a retired employee of the Chandanagar Municipal Corporation. Stop. His grievance is that the arrear revised gratuity and arrear revised pension was assessed by the corporation, but only an ad hoc sum of rupees 1 lakh was paid to the petitioner. Stop. The petitioner prays for releasing the balance area revised gratuity and the area revised pension in terms of ROPA 2019. Stop. The amount which is due and payable to the petitioner is appearing at page 17 of the writ petition. Communicated to the petitioner by order dated 9th March 2022. Stop. Next. Learned advocate representing the Chandanagar Municipal Corporation submits upon instruction that on account of financial crunch, full payment of pensionary dues could not be paid. Stop. It has been submitted that the due amount will be paid in favor of the petitioner within a very short period of time. Stop. Next. Paragraph. As the corporation has admitted the dues of the petitioner and has undertaken to disburse the amount,
Admissible amount.
disburse the admissible amount at the earliest. Accordingly, the present writ petition is disposed of by directing the
Commission.
employer, Chandanagar Municipal Corporation to take steps to release the balance payment in favor of the petitioner in accordance with law at the earliest, but positively within a period of 4 months from the date of communication of this order. Writ petition disposed.
Grateful orders.